May it please, your lord. Lord, may I pray for listing of a matter today, my lord, eviction matter, my lord, to be caused on tomorrow, my lord, 38th,
Hmm.
issued by my lord, the circle officer, my lord.
Okay.
Deeply obliged, my lord.
Wait, please, your lordship. Lordship, beg to mention item number 8, your lordship. There's some difficulty on a part today, your lordship.
Okay.
Item number 8, lordship. May I pray? Again, from
Hmm.
Your lordship, can it be taken up on 5th of June? Which is Thursday.
5th of June. Okay. Agreed.
lordship.
Okay. Mr. N. Gautam, Learning Council for the petition has prayed for an adjournment on the case. First of all, Mr. D. Hanapati, who is for the state?
Revenue.
Miss Revenue. Welcome. What the parties? Mr. M. Bormon. Revenue. My Portasage. Revenue. 1. M. Bormon. Junior Government 2. And Mr. D. Hanapati, Learning Council. That's 103 are present. First of, as sought for and agreed to by the Learning Council for the parties, lays the case on 5th of
June, lordship.
June.
Lordship. Obliged, lordship.
I have this humble prayer. Dear Lord, as regards item number 14, in the Parthard matter.
Yes.
Today, Mr. Admin is out of station with some difficulty today. I've taken a consult from Mr. A. Kotri also.
Okay.
May I pray, Lordship, in the next week on 6th, next Tuesday about 6th of May.
How much piece of meaning? Okay. I think it's ready. I think 29, na? I think it's ready. 29. 6th of May?
6th of
Okay. Under prayer, Mr.
AM.
A.M. Dr. Learned Council for the respondent. Coal India. Respondent Coal India authorities. Raise the case on 6th of May. Yes, it is submitted that consideration taken from Mr. A.K. Chaudhary, right?
Yes.
Learned Council for the petition to make the prayer.
May I please, your lordship? Lordship, I beg to mention item number 4 for adjournment.
4. Yes.
My senior is not available for the lordship.
Okay. On the Mr.
Mr. M.
Your
Rahman,
name, please.
M. Rahman on behalf of NZ.
M. Rahman. N. Rahman. The Learned Council, paying for Mr. N.J. Doctor.
NZ.
Learned Council for the petitioners. The case is adjourned for the day. A. Bhattacharya, M. Bormon, Silo are present.
Please, Lordship, I beg to mention item number 7. I'm appearing on behalf of respondent number 6 and 5.
6 and 5. 5 and 6.
Yes.
Yes.
I am for the petitioner, lordship.
Yes.
Okay, adjourn the matter today.
Okay.
After a week or
Mr.
C. Talukdar.
C. Talukdar, Learned Council for the respondent of 5 and 6, has made a prayer for adjournment of case for a week. Mr. M.K. Bora, Learned Council for the petitioner, Ms. Sailova, Revenue, and Government Advocate, Nombogeta Sailova, are present and have submitted that they have no objection to the said prayer. List the case accordingly after we're going to need to fix by the office.
Obliged.
Please, your lordship, with the consent of other side, I beg to pay item number 17 for filing a affidavit reply needs of time.
17.
17.
2015 song? You get it?
filing a affidavit in reply, my lord.
You were asked for or what?
Petitioner, compensation matter, my lord, land compensation.
You are for a petitioner?
My lord,
Okay, Mr.
SK Singh, my lord,
H.K.
Singh,
Singh,
my lord.
learned counsel for the petitioners. Has paid for 2 weeks' time to file an affidavit. Additional affidavit in reply to the additional affidavit filed by the respondent number 2. Okay, the praise the Lord, raise the case. After 2 weeks. Standing counsel, who is the standing counsel? Mr. D. Nath.
It for APGC.
Standing counsel, APGCL. And Ms. M. Borman, Junior Government Advocate, Assam for the state respondents are present.
May I please your lordship? I am praying for the listing of 2 writ petition. One is eviction matter for admission and the another one is for cooperative society matter for orders.
Eviction matter, motion.
Admission. Eviction matter is for admission.
Next week.
Next two. Obliged.
There is item number 9. I filed an additional affidavit on Friday. It is not on record. I am allowed to bring on same record.
Okay.
Supplementary list for motion. Item number 20.
Coming lordship is mentioning another.
Yes, anything?
Lordship, yesterday question was raised
Yes.
regarding maintainability
Mhm.
of the writ petition, Lordship. And the judgment I had placed before your Lordship. In that judgment, Lordship, there is a bar of if a person is not a member, he cannot challenge the election, Lordship. And a question was posed whether despite there being a bar, a voter can also approach the election tribunal, Lordship. I'm placing one rule. Notification issued by the government of Assam. Here, the only contesting candidate can. But if this notification was issued, Lordship, in exercise of power conferred under section 127 of the Assam Panchayat Act, Lordship, on the recommendation of the Guwahati High Court, Lordship. Here, the constitution of the election tribunal, Lordship. The kindly come to the 3rd page, Lordship. Jurisdiction. Jurisdiction, Lordship. The Panchayat Election Tribunal shall have jurisdiction to entertain and dispose of the election petition filed before it by any contesting candidate in respect of validity or propriety of the election, Lordship. So, being a voter, Lordship, he cannot file a election petition, Lordship. And the judgment I had placed before your Lordship, I think it has been also been reported in 2018-12 SSC, Lordship. The petitioner number 1 being a voter, Lordship, he filed a representation before the authority, Lordship, complaining about the ineligibility of the private respondent number 6. Lordship.
So,
Petitioner number
is it his fundamental right?
not fundamental right, Lordship, but there is a rule, Lordship.
Because the writ petition
Lordship, the statutory that
can be maintained on ground of infringement of fundamental right, constitutional right,
There is a provision,
Statutory right,
statutory lordship, is a
right.
violation of statutory provision lordship.
Ah,
He being a ineligible candidate lordship, his name have been abroad,
Who?
private respondent number 6.
No, I am on petition number 1.
Hmm.
Petition number 2 has the right to file an election petition according to your government notification,
Yes,
right? Now you're harping on petitioner number 1.
yes, lordship.
So I am asking you that what kind of right he enjoys
Lordship,
to maintain a writ petition,
lordship,
right? Because writ petition can be maintained on the ground of infringement of fundamental right, constitutional right, or statutory right, or other legal rights, right? So which right he is enforcing?
lordship, if a ineligible candidate is selected for the post of member lordship, there is a his credibility would be in question lordship, and the entire
No, to
entire
maintain a writ petition, firstly, forget about the private respondent. To maintain a writ petition,
yes,
that right to contest or right to elect
Hmm.
is not a fundamental right. Right to vote or right to contest an election, in my limited knowledge, is not a fundamental right. Right. And perhaps it is not a constitutional right. Right. Only right is a statutory right. And whatever is given by the statute, you have to be within the contours of that statute. Perhaps subject to correction. Now, if statute has not given any right to a person to contest acceptance or rejection of nomination to a voter, now he is a voter only. As on date, he is a voter. Since he did not submit any nomination paper, being a former president, that does not change his status.
Hmm.
He is only a voter as on date. Now, if it is not subject to correction, fundamental right to contest an election, if it is not a fundamental right or constitutional right, only a statutory right, then right to challenge might not be a fundamental right. Right to challenge acceptance or rejection of nomination paper of a candidate may not be a fundamental right or a constitutional right. You satisfy me on this point?
lordship,
And if it is only a statutory right, then it can be within the four corners of the statute,
lordship,
subject to correction.
if that be so, lordship, the right to express under Article 19, lordship, he expresses grievances before the authority, lordship,
That is not, that has not been recognized.
and the authority has not taken
What
any
can I do?
special
If
expression.
the constitution is not recognizing it,
And so, moreover,
you
lordship,
express everywhere, but not under 226.
lordship, the judgment we had, I had placed before your lordship yesterday, lordship. In that judgment, the petitioner is also merely a voter, lordship.
Hmm.
And the Supreme Court,
Hmm. What does it says?
Supreme Court has that no person should go
Ah.
any less, lordship. There a voter can also challenge the candidature of a elected candidate or contesting candidate. So it has been also been reported in
Okay,
2008.
then we have to issue notice. We have to issue notice. Without him being heard,
Lordship, I am not praying for stay or installing the election process, Lordship. I am praying for, and there is a provision in the act itself, in the rule, Lordship. The scrutiny officer can reject at the time of scrutiny or
There is no
receipt-
provision provided.
on receipt of any objection, Lordship.
There is no provision provided, sir,
The
to
Assam
examine it.
Panchayat Rules 1995, Lordship.
16 and 22.
22
Let us see.
2,
Is there any provision
Lordship,
to challenge it?
the officer as may be authorized under sub-rule 1
Hmm.
shall not be below the gazetted rank and
Hmm.
shall be appointed with prior approval of the State Election Commission. Such officers shall, Roman 1, shall be give the candidate or his proposer reasonable opportunity to examine the nomination paper and shall decide on the spot. The objection, if there be any, by summary inquiry, he may either on his own initiative or an objection raised, reject any nomination on any of the following grounds. Ground number 1, that is the candidate is not qualified under the provision of the act.
Sir, this has given, see, give the candidate or his proposer. It is limited to that particular candidate who is filing the nomination. Reasonable opportunity to examine the nomination paper and shall decide on the spot the objections, if there be any. Did you file any objection to the private respondent's nomination paper? Did you file?
We filed the object,
No, did you file?
yes, by way of,
Where?
by way of representation.
Where? Let me see the dates first. Last date of filing nomination, first phase or second phase?
That page 40.
The first phase or second phase? Your election,
First phase.
first phase. Last date of filing nomination is 11th. So when it was supposed to be filed then?
The date of publication of list.
Scrutiny of nomination paper, 12.
Before publication of list, we have,
Scrutiny of nomination papers,
yes, Lordship.
12/4.
The date of publication of list of validated nominated candidate, Lordship. After publishing of validated candidate, validly nominated candidate, we have filed the representation on 16. Lordship, and the date of publication of list of contesting candidate and list of contesting candidate was published on 17/4/2025.
It was supposed to be filed on 12th. It was supposed to be filed, it was required to be filed on 12th.
Lordship, for a moment, Lordship, kindly come to Article 243F of the Constitution.
220,
243F of the Constitution.
243,
F.
F.
Subject to correction, Lordship, whether it is totally attract to my provision of it is matter of interpretation.
No, I don't, I am not sure about anything. 243?
F.
F.
disqualification for membership. A person shall be disqualified for being chosen as and for being a member of the panchayat. B, if he is so disqualified by or under any law made by the legislature of the state. Lordship, that eligibility criteria was, Lordship, and Lordship, kindly see 243F. If any question arises as to the whether a member of a panchayat has become subject to any of the disqualification mentioned in clause 1, the question shall be referred for the decision of such authority and in such manner as the legislature of a state may by law provide.
That means what?
There no mention about the election petition, Lordship.
Constitution also says state legislature by law. What is the law? Panchayat Act. And what is under the Panchayat Act? 243O and 129. Yes. What about his decision, voter? It is amounting to stalling that election process.
Yes. But I have a submission to make in this regard. What my learned friend is harping on, filing of the writ petition, the answer lies in the second judgment of the apex court. 2018.
Which judgment?
2018. 6
This one?
Chitti.
Bharati Reddy?
Yes.
Hmm.
Both cases arise out of same. But there, if your lordship would see in the first judgment, there is no mention what is the nature of challenge.
Two judgments means
2017, my lord.
2007. I am not given the SCC copy. This is the, I don't know the report.
That lordship would see.
Ah.
There is no mention what is the nature. But the challenge is the election. My submission.
Oh, this is after election.
Yes. My respectful submission for your lordship consideration would be this.
Then it is a writ petition.
Yes, plus that. Lord, when an exercise of election is carried out, in between
If
there
a
cannot be
voter is not permitted to file an election petition, then he file a writ petition.
writ petition, and that too on a limited ground, and Lord, that relief should be quo warranto. Because
Petitions are filed.
yes, Lord, not in the per se certiorari proceedings without quo warranto. But in this case also, Lord,
Writ petitions are filed. We are entertaining that.
yes,
This lady, man had 4 children. This had no something like that.
my lord.
All these are there. Writ petitions are entertained. But question is the moment.
Yes, moment is after Lord he is elected. Lord, if the writ
First
petition-
line. First line, sir, your judgment. Bharati Reddy.
2018-12 SCC, Lordship.
No.
No, your Bharati Reddy judgment. Your trump card. Your trump card.
Because otherwise it's premature. Who knows, Lord, if he wins or lose?
The appellant was elected as a member. In that context, since rule does not permit, Panchayat Act does not permit, then the Supreme Court referred to basic structure, Kesavananda Bharati and all this, then why a writ petition cannot be maintained. He should not be left remediless. For petition number 1, after the election, result is declared. For petition number 2, election petition.
My submission would be on that too on limited ground, Lords. Because the
Will not go into that limited ground eligibility. That is, we are not deciding on the eligibility of the private respondent.
Lord, I tried to find out, Lord, this issue, perhaps your lordship may be laying down a law on this aspect. Because, Lord, my submission would be that only once the person is elected, the non-voter, the voter or non-candidate can file only as regard the eligibility. Same, Lord, if there are some issues as regard the manipulation or something in the election process, that locus he doesn't have. And the very fact that
those issues are already settled by a long line of decisions, right from after the constitution itself. We are not reiterating that. But if only option remedy, if under this particular judgment
My lord.
for the petition number 1
Yes.
is
Writ petition.
writ
by two-
petition after declaration of result, and that is 50-50. If the private respondent is not elected, he
Yes.
has no grievance
No grievance.
because he is supporting the petition number 2 as a candidate.
My lord. So at this stage, it is not maintainable. It would be a premature, my lord.
Yes, other writ petitions. Your judgment goes against you.
Lordship, there are judgment, Lordship, other judgment also.
All our judgments distinguishable.
Before election, Lordship.
You are halting. You are trying to halt the election process
Lordship, he-
because remedy is available for both the petitioners. For the petition number 2, absolutely clear. And any objection, it should have been filed because on the spot. Objections on the spot. See,
But even also, my lord, if objection is.
shall
filed-
decide on the spot. The objection, if there be any,
my lord, if-
on the spot,
but even there is a
not
wrong decision
after-
also.
afterthought.
Even there is a wrong decision, my lord, that only can be put to challenge in election period, not. at
It may
that
be
time.
wrong.
Yes.
I am not saying, I am not
My lord,
justifying that the nomination, acceptance of the nomination paper of the private respondent was correct.
Correct.
I am not saying that.
Yes.
I am saying about the,
Yes. But that
Locus-
validity exercise can only be done after the election results. sir.
yes. For petition number 1 is clear now.
It is not a case that I am storing the entire process of this is a ward member, he is only a ward member of a particular panchayat.
Romila, you're right. This goes against you now. Your trump card. What next?
If in
Show us, show us, show us. I asked you, bring all your arms and ammunitions. Yesterday I said, your trump card goes against you.
Lordship, just
Yes, what are other petitions? Show me judgment.
Lordship, in earlier occasion also, this court Lordship has entertained the 226 petition Lordship.
Okay, which one?
Indemnity of
Show me. I have asked you yesterday. Come prepare. Laying down law.
not later.
Huh?
There is a
Notice of motion.
no Lordship, it has been disposed of.
Show us.
After election. The candidate's nomination has already been accepted, but symbol was not given to the candidate Lordship.
Oh, this is different, sir.
We considered that.
This is different, sir.
Lordship, I'm since Lordship, I made a complaint before. the
This is for a fair election. This is for the purpose of free and fair election. You had a counsel there.
Not Lordship.
It is for the purpose, the
Last-
unjustly
last
denied
it was
My
there.
friend was there.
symbol to the Trinamool Congress. That is for the purpose of facilitating free and fair election.
Lordship, if a disqualified candidate, Lordship, contest election, Lordship, and he is a apparent on the record that he is ineligible, Lordship, can he? those
We are
things-
not examining as on date, sir,
Unsaid-
his eligibility or otherwise. If your otherwise, I don't know, if your argument is to be accepted, then no, there will be no parliament,
And floodgates of. writ petition
no
open.
legislative assemblies, no elected representative in a panchayat.
Lord, your lordship would burden with series of cases.
These, just because contract is there. We are not expressing any immediate, you reserve your all energy for the repetition and the election petition. Yes, item number 2 and 3.
In my case, my lord, on the spot, my lord, on the date of
Now,
scrutiny of the nomination paper, my lord, was 12/4/2025. On that spot, my lord, we, my lord, filed representation for cancel disqualification.
your representation?
12, my lord, 4, my lord,
Hmm.
page, my lord, 18, my lord.
Hmm.
On the spot, my lord, it was filed, my lord.
Monon Patra, ask, who are you?
Page 18, my lord.
Government. Jila Parishad.
Yes, ma'am.
Accepted the
Private respondent, my lord, she is the owner of a government fair price shop.
your synopsis said petition after coming to know that the respondent authorities accepted the candidature of the private respondent.
But my lord,
Where is the schedule?
my lord, page
First
14
phase or second phase?
second phase, page
12
14,
4.
1/4, my lord.
To Zila Upayukta.
My lord,
So he is the election officer.
my lord.
This officer?
Returning officer, yes, ma'am.
Under Rule 22?
Yes, my lord.
He is the officer.
Yes,
The officer as may be authorized under Sub Rule 1. He is the officer.
deputy commissioner.
No, I am asking you.
Yes, my lord.
Under Rule 22 of the Assam Panchayat Constitution rules, he is the officer.
Yes, ma'am.
Let us see the content. This is not on the spot, paragraph
Yes, ma'am.
6. No,
Yes.
paragraph 6.
But my lord, kindly turn to page 14, my lord.
No, paragraph 6.
Ma'am.
Your statement.
My lord. Page 4, my lord.
Hmm.
And page 14, my lord. Date of scrutiny, my lord. 12/4.
12.4. No, your statement after acceptance. Not on the spot.
But
Everything can happen after acceptance.
date is, my lord.
Date does not matter. Matter is on the spot.
But even if we accept or reject, decision is being taken. So, on the spot objection also will not count.
Unlike in
Because-
Municipal Act, there is no such.
No.
Or there is provision in the Cooperative Societies Act also.
Yes, yes.
You can file
Register,
to the registrar within 3 days from the acceptance of nomination
because
paper.
they ultimately they have to approve
Likewise in the Assam Municipal
16C.
Act. But here legislature consciously maybe is not putting any option for
Yes,
filing an appeal because perhaps municipal areas are less, panchayat
Yes.
areas are huge.
my lord.
If this
Exercise
option is
three.
allowed,
My lord, we
there will be
create-
thousands and thousands of applications. If this is to be allowed, perhaps this is a region.
So the purpose of on the spot is this, my lord, that the returning officer can take a decision,
On the spot, take a dish.
make a decision. Even if he has taken a wrong decision, then still
in-
remedy
in-
is available.
See, on the other hand,
My lord.
if objection is filed, then private respondent's nomination is cancelled. He has no option.
And you'll also have. to
He'll
file
have
the-
also have to wait up to declaration of results to file a election petition.
But our, my lord, representation has not been disposed of.
Not required. Absolutely not. Then I'm not required. I'll observe, not required to be dismissed, disposed of. I'll observe.
Because he has no jurisdiction when he accepted.
No
the nomination.
jurisdiction. He cannot assume any jurisdiction. If he does it, then it is wrong. And who is the election officer otherwise?
But it says district commissioner.
District Commission.
Election officer. He signed. District commissioner.
District, election
Ah.
officer would be the district commissioner, my lord, and
Okay.
there may be, my lord, returning officers, my lord, who will be scrutinizing those people. My lord.
Any person whose name appears who is not disqualified may be nominated as a candidate from the for election to a member of so and so, so and so. Nomination papers shall be delivered either by the candidate or his proposer to the officer authorized by the district commissioner, or the officer as authorized by the district commissioner, as the case may be, for the purpose, who shall be present on the date, at the time, and place notified for filing the nomination under sub-rule 1(3) section, and this will also have a copy of electoral roll of the so and so, diameter, size, so and so, provided that no person shall be nominated as a candidate. As a result, what happened? How many candidates now? You are a candidate.
Yes, ma'am.
Your nomination is accepted.
Yes.
His nomination is, respondent number 5.
Yes, ma'am.
What is your objection for her nomination?
My lord, she is a owner of a government fair price.
Hmm?
dealer, my lord. Government fair price shop, my lord.
Owner.
Yes, ma'am.
You have your option. Then next.
There are only two persons submitted nomination paper, I and the private respondent. But what happened,
Did you submit the affidavit?
my lord?
Did you submit a affidavit, the affidavit that you had sanitary latrine?
Yes, everything. was-
Where is that?
Oh, here I am now.
Where is that?
But they private candidate.
Your statement is that your nomination might perhaps been rejected,
Yes,
right?
but they inform, orally inform, but no reason, my only grievance is this.
I think it is a requirement to submit an affidavit.
We all submitted everything,
No,
but
you-
here I am not in the next, but.
Not even statement,
So that there-
not even statement, sir.
No, no,
You said that sanitary latrine,
my lord,
perhaps, paragraph 10. But anywhere in your written statement, you said that I had submitted the affidavit. I think you have not enclosed the terms and conditions. In the first petition, perhaps. Did you say, you know, your
Lord,
ground of
My lord,
rejection?
your lordship kindly see paragraph 16.
Paragraph
the-
16.
Yes, the petitioner has submitted his nomination paper by annexing all required documents such as school certificate, admit cards, proper certificate, Bajik clearance certificate, bank clearance certificate, certificate of the Gaon Panchayat, caste certificate, death clearance certificate from the Gagolmari SS Limited, debt clearance certificate from Mayang Anchalik Panchayat, debt clearance certificate from the Morigaon Jilla Parishad, passbook, so caste certificate, PAN card, voter ID, Aadhaar card, including affidavits as required.
Including affidavit, very vague,
As required.
very
And
vague.
as much nomination paper in order in law respect. But only there on your last a complaint. The private has two candidates, my lord. The private candidate, he lodged a complaint.
As soon as his,
But that complaint also not served on me. Then hearing was taken place on 12.
not required, it is on the spot, everything.
Now, I am not complaining. They have held a
Hmm.
private who are the in the now career.
Ah.
He lost complaint against me, my lord.
Where is your affidavit then? You have annexed all the photocopies. Where is your sanitary toilet affidavit? What is the condition, Mr. Dubey? That there should be an affidavit.
Yes, Lord. Mention.
And maybe first in the first writ petition.
Yes. Page 21, if your lordship sees in the first writ petition.
21 contest function.
This is
Ah.
From section 1.
Candidate want to contest in the panchayat should have a functional sanitary in his residence, self-furnished affidavit as in schedule 2 along with nomination form as in rule 62. Rule
I-
62.
This is the copy of the affidavit, my lord.
Rule 62.
Yes, sir. I have sanitary. Sanitary lectin. This is the affidavit, my lord. My only case is just result has not been furnished to me, my lord. What is the ground, on what ground my nomination has been rejected? But no,
No. How can this be affidavit? How can this be affidavit?
Latin paragraph. This is the motive sense.
No, it is a plain paper.
No, my lord. Itu ya, IPI stem. But what his type of complaint has been lodged, I have no knowledge. Copy not served on me. However, we appeared. But thereafter, final list of candidates published only by showing the name of private testimony. No reason has been given. I have not know nothing till day how my nomination has been rejected. And those are not the grounds also for rejection by nomination paper. If suppose I have no single letter, then also there is no ground for rejection by nomination paper. And reason of nomination paper clearly mentioned here.
And what all you have to say regarding the decision of this court?
Not
Coordinate bench. Coordinate bench decision which has been referred by Mr. Dubey yesterday.
Lela, yes. that election petition is maintainable, but question is, well, how can I file, even I cannot file the election petition, my lord, because reasons has not been furnished to me till date, my lord. Why?
That is a very good ground.
Then election petition, my lord, I will file election petition, but only I file this petition only for the purpose of to know why my nomination paper has been rejected. Because your lordship, this is rule 22, here the reason has been given how the nomination paper can be rejected. Except those ground nomination cannot be rejected, my lord. Suppose I have no secondary, I have nothing, but that is not a ground for rejection my nomination paper. Rule 22, my lord, clause 2, subclause 2.
As a result, what happened? The other candidate,
He only one candidate.
only one candidate.
One
Then
candidate.
you have better chance. Get him disqualified and get yourself qualified. You'll be a member.
It is correct, but only my reason, why they did not furnish the reasons.
Now, how to overcome the coordinate bench judgment?
Yes, it is binding.
Huh?
It is binding.
How to overcome?
My lord. Some observation, my lord,
I
that
think your lordship may say that he may be provided with a copy of the
Yes.
rejection so that
that may be.
facilitate.
I can challenge the election petition. My lord. Thanks, my lord.
I am bound by the
Yes, my lord.
judgment of the coordinate bench.
Hello, I am not disputing.
And it has discussed every judgment,
Yes, my lord. But
holding the field.
I have gone through the judgment.
Uh,
I have gone.
yes, what do you say about the coordinate bench judgment?
It is binding on us, my lord. I know.
The power of judicial review.
This cannot be taken away. That is Kesavananda Bhavi, that is there. But on the basis of the facts of the case,
And division bench.
how do you distinguish?
Division bench also give some observation that such a matter cannot be in favor.
Okay.
Hello, please.
As all the three petitions, instituted under Article 226 of the Constitution of India, involve similar nature of issues. And having regard to the point of law involved, all these petitions, all the three petitions are taken up together for final consideration, as at the instance of the learned counsel for the parties. Full stop. The writ petitions have been preferred by the petitioners either against rejection of nomination papers or acceptance of nomination papers. Full stop. Though facts are not required to be narrated in detail, in order to appreciate the issues involved in the writ petition. The relevant facts involved in each of the writ petitions are exposited, briefly, herein below. Full stop. Para. In the writ petition, WBC number 2174, 2025. Two writ petitioners, huh? 2178, okay. Two writ petitions have joined to assail acceptance of the nomination paper of the respondent number 6 implemented, or the party respondent number 6 implemented therein. Full stop. The petitioners have projected that the petitioner number 1 is a former president of Kothalguri Gaon Panchayat, and his tenure expired in February 2024. Full stop. The petition number 2 has aspired to be a Gaon Panchayat member from ward number 1 within bracket Buralik Son Gaon under Kothalguri Gaon Panchayat, and for the purpose of contesting the election from the said ward, the petitioner number 2 submitted her nomination papers within the prescribed date for submission of nomination papers before the election authority of Golaghat district. Postal. ইয়াৰ আগত এটা পেৰা থাকিব হা, টেবুলখন থাকিব। As per the notification dated 2/4/2025, the last date of filing nominations was 11/4/2025. Post op. The date for scrutiny of nomination papers was fixed on 12/4/2025. Full stop. It is a case of the petitioners that the respondent number 6 had also submitted his nomination papers to contest the election from the same ward as the petition number 2. Full stop. The petitioners have claimed that the respondent number 6, the nomination papers of the respondent number 6 ought not to have been accepted by the officer authorized to accept the nomination papers. Full stop. It is the case of the petitioners that the respondent number 6 is suffers disqualification under section 111 within bracket 1 within bracket E of the Assam Panchayat Act as he is an owner of an IMFL shop after entering into an agreement with the government under the Assam Excise Act 2000. Full stop. With such projections, the petitioners have,
Registered.
huh?
He is also a registered vendor under Jilla Parishad. A vendor for supplying.
In addition, the respondent number 6 is also a registered vendor under the Panchayat authorities to supply materials. Full stop. With such projections, the petitioners have sought a writ in the nature of such a right to set aside the candidature of the respondent number 6 for the post of Gaon Panchayat member from ward number 1 within bracket Buraliksan village, bracket close, under 35 number Kothalguri Gaon Panchayat, Golaghat, post of para. In the writ petition, WPC number 2186, 2025, comma, the petitioner submitted her nomination papers for to contest for the for the post of a member to the Goroimari Jila Parishad. Goroimari Jila Parishad or what Parishad?
Yes.
Goroimari Jila Parishad, District Kamrup Rural. District Kamrup Rural. So the petitioner has stated that her nomination papers were duly accepted by the officer appointed to authorized to receive the nomination papers. Full stop. The petitioner has contended that the respondent number 6 5 pursuant to the notification dated 2/4/2025 had also submitted nomination papers to contest the election for the post of member of the Jila Parishad from the same constituency. From the same constituency.
Yes, same.
Huh?
Same Lord.
Same.
Full stop.
3 nong Goroimari Jila
The
Parishad.
petitioner's
Number
contention is
3.
that the nomination papers of the respondent number 5 ought not to have been accepted as CJ licensee of a fair price shop under Messrs. Goroimari ZPSS Limited. Full stop. It is the further case of the petitioner that after coming to know that the respondent authorities had accepted the nomination papers of the respondent number 5, the petitioner submitted a representation before the district commissioner, Kamrup Rural, stroke election officer on 12/4/2025 itself, requesting cancellation of the nomination papers, stroke candidature of the respondent number 5. Full stop. As no action was taken on the said representation dated 12/4/2025. The petitioner is before this court by the instant writ petition, seeking inter alia direction to the respondent authorities to cancel the candidature of the respondent number 5 and to prevent her from contesting the election for the post of member to the Jila Parishad, Goroimari Jila Parishad from the same constituency as like the petitioner. Post of. The petitioner in the petition, WBC number 2202/2025. has instituted the writ petition, being aggrieved by rejection of his nomination papers he has submitted to contest as a member of number 4, as a member to Pobhakandi Gaon Panchayat, as a member of Pobhakandi Gaon Panchayat from number 4 Gorubandha constituency. Huh?
Wouldn't we get ka?
Ka. What means cow? Ko. Ka. First of all. The petitioner has contended that he submitted his nomination papers along with all the requisite certificates page 11 of school survey admit card so and so gaura certificate baki jaye bank clearance certificate पर गांव पंचायत लिखा है including the affidavits as required on 11/4/2025. Full stop. As per the schedule, as per the date, 12/4/2025 was fixed for scrutiny of nomination papers and publication of list of validly nominated candidates. Apart from the petitioner, another candidate within bracket the respondent number 11 submitted nomination papers to contest the election for the post of Gaon Panchayat member from the same constituency as like the petitioner. The petitioner came to learn that the respondent number 11, he is a contesting candidate, submitted a complaint on 11/4/2025 against the petitioner. So on receipt of the complaint, the authorized officer issued a notice to the petitioner on 12/4/2025 asking the petitioner to be present for a hearing scheduled on 12/4/2025 itself. First of, it is the contention of the petitioner that the authorized officer did not furnish a copy of the complaint to the petitioner along with the notice. And as such, the petitioner was not aware about the reason for filing the complaint. First of, the petitioner has contended that due to non-supply of the complaint, the petitioner could not present his case properly before the authorized officer. In the hearing held by the authorized officer on 12/4/2025. However, the petitioner came to know from sources that the petitioner's nomination papers might have been rejected on the ground that the petitioner had no personal latrine and there were discrepancies in his date of birth in the Aadhaar card and the school certificate. Full stop. When the list of validly nominated candidates was hanged on 12/4/2025, the petitioner, to his surprise, found that his nomination papers were not accepted and only the name of the respondent number 11 was shown as a validly nominated candidate. First off, as a result, the respondent number 11 might be declared as a elected candidate from the constituency. Gaon Panchayat number 4 to Gaon Panchayat constituency. First off, challenging non-acceptance stroke rejection of the nomination of the petitioner. The petitioner has issued the writ petition. First off, para. I have heard Mr. S.H. Sigdar, the counsel for the petitioner in 21. What to give? B. Haldar, like counsel for the petition in 20. J. Ahmed, like counsel for the petitioner in 22. I have also heard Mr. K. Kaur, learned senior standing counsel, Panchayat and Rural Development Department. Additional Advocate General. So, Standing Counsel, Panchayat and Rural Development Department for the state respondents. And Mr. R. Dubey, learned Standing Counsel, Assam State Election Commission. Full stop. Where, as from the facts narrated above, it can be noticed that the repetitions have been preferred by the petitioners in 20 and 21 against acceptance of the nomination papers of the private respondents implicated therein. Whereas the writ petition W22 has been preferred by the petitioner challenging non-acceptance stroke rejection of his nomination. Poster. Para. Itu para একদম আগতে হ'ব। Jasmine, some part 9. It will again. Who is Jasmine to go to? Part 9. Part 9 of the Constitution of India, titled the Panchayat was inserted by the Constitution 73rd Amendment Act 1992. Full stop. Part 9 of the Constitution contains Article 243 and Article 243A to Article 243O. Full stop. Article 243K has provided for elections to the panchayats. Full stop. As per clause within bracket 1 of Article 243K, the superintendence, direction and control of the preparation of electoral rules for and the conduct of, all elections to the panchayat is vested in the concerned state election commission. Full stop. As per clause 4 of Article 243K, the legislature of a state may, by law, make provision with respect to all matters relating to, or in connection with, elections to the panchayats, subject to the provisions of the Constitution. Full stop. Para. The Assam State Election Commission in exercise of the it is in the Assam Panchayat Act 1994. Oh, no, sorry, after insertion. After insertion. After insertion of Part 9 to the Constitution by the Constitution 73rd Amendment Act 1992, Assam, the State Legislative Assembly enacted the Assam Panchayat Act 1994 to amend and consolidate the laws relating to Panchayat in Assam to be in conformity with the provisions of Part 9. Full stop. Para. As per Section 114. It is in exercise of powers conferred under Article 243K of the Constitution and Section 114 within bracket 1 of the Assam Panchayat Act 1994, as amended, read with Rule 15 and Rule 16 of the Assam Panchayat Constitution, Rules 1995, framed in exercise of the powers under Section 141 of the Assam Panchayat Act 1994. The Assam State Election Commission issued a notification on 2/4/2025, notifying the schedule of general election to the panchayat in the state of Assam. Full stop. As per the notification dated 2/4/2025, the general election to the panchayat in Assam would be held in 2 phases, as per the schedule enclosed therein as Annexure 1. Full stop. For ready reference, the contents of Annexure 1 to the notification dated 2/4/2024 are extracted herein below, page 17. Para. In the as per as the provisions of Rule 16 and Rule 22 of the Assam Panchayat Constitution Rules 1995 are of relevance and import in the cases in hand, the same are quoted herein below for ready reference. Para. 16 and 22. Rule 16 within bracket one. Within bracket B has provided for publication of a notice, has prescribed for a publication of a notice intimating the date on which, the place at which, the hours between which the nomination papers would be taken up for scrutiny, such date being within 3 days after the date of submission of nomination papers. Full stop. In the cases in hand, the date for scrutiny of nomination papers and publication of list of validly nominated candidates was 12/4/2025. Full stop. Rule 22(1) within bracket 1 has provided that any person whose name appears in the list of voters, an intending candidate has to submit his nomination paper before the officer authorized by the district commissioner also. As per Rule 22 within bracket 2, the officer authorized to accept the nomination paper shall A. Examine the nomination papers on the date, time and place notified for the purpose under the rule, semicolon. And B. Give the candidate or his proposer reasonable opportunity to examine the nomination paper and shall decide on the spot, comma, the objections, comma, if there be any, comma, by summary inquiry. Full stop. From rule 22 within bracket 2, it is discernible that the authorized officer has to examine any objection received by him as regards nomination of any candidate on the spot by way of a summary inquiry. Full stop. Insofar as the two repetitions, repetitions, comma, W, item 20 and 21. It is not the case of the petitioners that there was any complaint, stroke objection to the before the authorized officer objecting to the nomination stroke candidature submitted by the private respondents therein before the authorized officer on the date on which, comma, the place at which, and hours between which the nomination papers were taken up for scrutiny. Full stop. On the other hand, comma, the respondent number 11 impleaded the respondent impleaded as respondent number 11, private respondent impleaded as respondent number 11 in WBC number so and so appeared to have submitted a complaint before the authorized officer against the nomination stroke candidature submitted by the petitioner, and it transpires that the authorized officer had accepted the complaint and had put the petitioner on notice for a hearing by way of a notice dated 12/4/2025. So a hearing was scheduled on 12/4/2025, and thereafter the hearing was held on 12/4/2025. Full stop. It thus transpires that the authorized officer had decided on in the matter of acceptance or non-acceptance of the nomination of the petitioner on the spot by way of a summary inquiry. Full stop. It is another region. No, full stop. The petitioner in 3 had still a grievance, that the reason for rejection of his nomination was not informed to him in writing by the authorized officer. Full stop. Comma. The issue which has arisen for consideration is whether for acceptance of nomination of a particular candidate or rejection of a nomination of a particular candidate, whether a writ petition under article, whether the extraordinary and discretionary jurisdiction of this court under Article 226 of the Constitution can be invoked, raising a grievance as regards acceptance of nomination of a candidate or rejection of nomination of a candidate, prospective candidate. In view of the provisions contained in the part 9 of the part 9 of the Constitution of India and the Assam Panchayat Act, full stop. Para. The learned counsel for the parties have referred to a number of provisions of part 9 of the Constitution of India, specifically to Article 243O B and Section 129 of the Assam Panchayat 129B of the Assam Panchayat Act 1994 as amended. Full stop. Para. Article 243O has created a bar to interference by court in electoral matters. Full stop. Similarly, Section 129 has created a bar to interference by courts in electoral matters. Full stop. As the said to Article 243O and Section 129 are perimeter provisions, and full stop. They read as under 243O to 129. Para. In the cases in hand, we are concerned with Article 243OB and Section 129B. Both the provisions are with a non-obstante clause. Full stop. It is prescribed, it is stipulated, it has been stipulated therein that no election to any panchayat shall be called in question except by an election petition presented. No. As per Article 243 OB, no election to any panchayat shall be called in question by an election petition presented to such authority and in such manner as is provided for or by under any law made by the legislature of a state. Full stop. The expression, quote unquote, any law made by the legislature of a state, unquote, which appears in clause B of Article 243O is relatable to the Assam Panchayat Act 1994 as amended. Full stop. As per clause B of Section 129, which is also with a non-obstante clause, no election to any panchayat shall be called in question except by an election petition presented within 60 days from the date of declaration of election results to the tribunal constituted under Section 127. Full stop. Hey, moi eta 127 order disilo na kaumata side like disilo na man assumption of jurisdiction. As per the provisions of section 127 of the Panchayat Act, the government shall constitute such Panchayat election tribunals as may be necessary, on the recommendation of the High Court, to dispose of all direct elections, challenging elections under the Panchayat Act. Full stop. The jurisdiction, powers and functions and the headquarters of the tribunal shall be decided by the government in consultation with the High Court, except as provided in section 10 of the Panchayat Act. Section 10 of the Panchayat Act is for election of president and vice president of Gaon Panchayat. And it is not necessary for the purpose of consideration of this batch of petitions. More particularly, in view of amendment, recently amendment carried out, right? Now this is not, provision is changed.
There is no directly. Earlier it was right,
Ah.
now.
It has been changed or what? Section
If
10.
Now you need to Gaon Panchayat,
Let us see section 10.
president would be,
Ah,
you get, from the, what they percent.
after the election. Post. Why is the notification? They continue. Thus, it is evident that it is the state government who has been given the authority to constitute the Panchayat Election Tribunal on the recommendation of the High Court. Full stop. The jurisdiction of such Panchayat election tribunals is required to be decided by the government in consultation with the High Court. Full stop. Article 243F of the Constitution mentions about disqualification for membership. Full stop. Subclause B. Of clause 1 of Article 243F has prescribed that a person shall be disqualified for being chosen as, and for being, a member of a panchayat if so disqualified by or under any law made by the legislature of the state. Full stop. Subclause 2 thereto has provided that if any question arises as to whether a member of a panchayat has become subject to any of the disqualifications mentioned in clause 1, the question shall be referred for the decision of such authority and in such manner as the legislature of a state may, by law, provide. Full stop. But there is no dispute to the fact that the Assam Panchayat Act by the Assam Panchayat Amendment Act 2018. Section, Chapter Roman 8, title, Disqualification of the President, Vice President and Member of Jilla Parishad, Anshalik Panchayat and Gaon Panchayat of the Assam Panchayat Act 1994 has, as amended, has provided for disqualification of a person to be elected or co-opted or remain as President, Vice President or member of Jilla Parishad, Anshalik Panchayat and Gaon Panchayat. Posta. In the writ petitions, in the present writ petitions, the petitioners contention regarding acceptance or non-acceptance of the nomination paper are relatable to one or the other disqualifications delineated in section 111. Full stop. Era. A member of a Panchayati Raj institution who has purportedly incurred a disqualification under section 111 of the Assam Panchayat Act can only be removed by way of an election petition presented before the Panchayat Election Tribunal. Full stop. In that connection, a reference can be made to a notification bearing number PDA .277/2000/32 issued by the Panchayat and Rural Development within bracket A Department, Government of Assam on 39/2000. First up, by the notification dated 39/2000, the Government of Assam, in exercise of its power conferred under section 127 of the Assam Panchayat Act 1994 as amended, and on the recommendation of the High Court, had constituted one number of Panchayat election tribunals with the district judges within their respective territorial jurisdiction to dispose of all direct elections challenging election under the Assam Panchayat Act. Full stop. The jurisdiction of the election tribunal have been specified as under jurisdiction clause that answer. Jurisdiction, the Panchayat election tribunal shall have jurisdiction to entertain and dispose of election petition filed before it by quote unquote any contesting candidate in respect of validity or propriety of the election. Post. Quote unquote, para. A reading of the jurisdiction clause in the said notification makes it apparent that the Panchayat election tribunals shall have jurisdiction only to entertain and dispose of election petitions filed before it by quote unquote any contesting election in respect of validity or propriety of the election. Post. It is settled that a tribunal assumes jurisdiction on a particular matter when such jurisdiction to entertain a particular matter has been vested in such tribunal. Full stop. In other words, existence of jurisdictional fact is sine qua non for any tribunal to exercise jurisdiction on a particular subject. If the jurisdiction on a particular subject is not vested in a tribunal, then the tribunal cannot exercise jurisdiction on such matter. Full stop. Para. Mr. Haldar and a counsel for the petitioner in 20 has advanced a submission that as the jurisdiction of the election Panchayat election tribunal constituted under article section 127 of the Assam Panchayat Act equal to 92. To entertain is limited in the sense that it can only entertain and dispose of an election petition filed before it by any contesting candidate in respect of validity or propriety of the election, in such a case, the Panchayat election tribunal has no jurisdiction to entertain and dispose of an election petition filed before it by an elector or voter, even if he has a valid cause of grievance to the acceptance of nomination paper of a person who is apparently disqualified to contest an election and he will be left remedialess. Post up. Relying on a decision of the Honorable Supreme Court in SCC. What is the citation? Do you have the copy? Hand over.
I think the citation is different.
Huh?
The second citation.
Please, Paul. Enlighten me. I don't have the citations. কি করলো? In Bharati Reddy versus State of Karnataka and others, reported in 2018, 12 SSC 61. Same. Comma, he has submitted that the petition number 1 cannot be left remediless. And the writ petition preferred by the petition number 1 is maintainable and is to be entertained. Comma, even if it is assumed that the petition number 2 being a contesting candidate, comma, is to be relegated to the Panchayat Election Tribunal. Full stop. With such contention, comma, Mr. Haldar has submitted that the writ petition, WBC number, item number 20, is maintainable insofar as the petition number 1 is concerned. Full stop. Or contrary. Mr. Dubey, Land Standing Council, ASEC, by referring to Bharati Reddy Supra, comma, has contended that the submission advanced by the Learned Counsel for the petitioner is misconceived in the sense that in Bharati Reddy Supra, comma, the High Court dismissed the writ petition
There is another good judgment following this.
I have been given only one judgment. Huh?
What happened in the first round of litigation, Apex Court has allowed the writ petition or filing and leaving it to the High Court to decide the issue.
Right.
Then when the issue was decided again, it went to Apex Court.
Okay, show me the citation. Give me the citation.
Mine is the
if you, at least the citation, give me, I can take out.
18.6 SCC 160. See the prayer put it in the what the reputation that was finally. Just say it was not decided that the revision under infinity of the petition under article is taking away. Here in that case only it was decided since the issue was pending before the last verification committee. The learned singles are set aside the nature of the evidence. And the FX code logic intentional issue there was again sent back to the class verification committee to decide the matter.
That is a different issue.
Yes, sir. No, went down with the.
Equal line to years. Now we go, now we. Inverted ready supra. Comma. Four voters. Filed a writ petition before the Karnataka High Court challenging the election of the appellant on the ground that the appellant contested the election on the basis of a false caste certificate. And the High Court dismissed the repetition on the ground of maintainability in view of the bar contained in clause B of Article 243 O of the Constitution. Full stop. In order to appreciate the rival contentions made with regard to the observations made in Bharati Reddy Supra, comma, it is apposite to look into the background facts therein. Full stop. The appellant was elected as a member of Jilla Parishad from a constituency, comma, which was reserved for general within bracket Omen category in the Panchayat election held on 20/02/2016. Full stop. The state government, by issuing a notification, notification dated 15/4/2016, the state government reserved the post of Adhyaksha of Jilla Parishad of the particular Jilla Parishad for backward class B within bracket omen. Full stop. The appellant contested for the said office and was declared as elected. Full stop. The respondent number 6 to 9 were residents of Bellary district and were voters in the election to the Zilla Parishad in question, presented a writ petition before the High Court challenging the election of the appellant as the Adhyaksha, mainly on the ground that she did not belong to backward class B and she had contested the election on the basis of a false caste certificate issued in her favor. Full stop. The appellant raised objection as to the maintainability of the writ petition having regard to the bar contained in clause B of Article 243 of the Constitution. And it was contended that the aggrieved party had to challenge the election by way of election petition before the jurisdictional election tribunal. Full stop. The Honorable High Court dismissed the writ petition on the ground of maintainability in view of the bar contained in clause B of Article 243 of the Constitution. Full stop. The respondent number 6 to 9 learned single judge, dismissed the writ. A learned single judge took the matter before the division bench, and the division bench set aside the order of the learned single judge by holding that the writ petition was maintainable. Full stop. The division bench remanded the matter to the learned single judge for fresh disposal of the case, keeping open all the other questions. Full stop. The appellant had challenged the legality and correctness of the said order of the division bench before the Honorable Supreme Court. Full stop. The Honorable Supreme Court had examined the VAR containing, examined the provisions of Part 9 of the Constitution, including the bar contained in Article 243O. Full stop. In the concerned rules of the concerned Panchayat Act of Karnataka, the Adhyaksha and Upadhyaksha of the Zilla Parishads were to be elected in accordance with the provisions contained in section 177 therein. Read with rule 7. In the concerned Panchayat Act and Panchayat rules of the state of Karnataka had provided that any member of Zilla Parishad, in whose jurisdiction the Zilla Parishad lies, can question the election of the Adhyaksha and Upadhyaksha before the jurisdictional district judge within a period of 15 days from the date of declaration of election results by depositing concerned requisite fee along with an election petition. First off, the Honorable Supreme Court took note of the fact that the statutory provisions did not allow a non-member of the Zilla Parishad to maintain an election petition. Full stop. It is in that context, comma, the Honorable Supreme Court has held that if the voters are aggrieved by the election of a candidate to the office of a panchayat, they, he or she, if a voter, or they cannot challenge the election they are aggrieved by the election of a candidate to the office of the Adhyaksha of a Zilla Parishad. They cannot challenge the election of such candidate to the office of the Adhyaksha by filing an election petition in view of the statutory provisions debarring the non-members of the Zilla Parishad to prefer an election petition. Full stop. The Honorable Supreme Court has proceeded to hold that a voter of the Zilla Parishad who is not a member cannot be denied an opportunity to challenge the election to the office of the Adhyaksha under Article 226 stroke 227 of the Constitution, and has held that if a voter prefers a writ petition before the High Court, the same would be maintainable. Full stop. Para. One of the facts which have emerged from the decision in Bharati Reddy Supra is that the writ petitioners as the voters therein had instituted the writ petition under Article 226 of the Constitution after the appellant therein was elected as a member of the concerned Zilla Parishad and thereafter, elected as Adhyaksha of the Zilla Parishad, which post was reserved for general within bracket women category. Full stop. The Honorable Supreme Court, while deciding the appeal in Bharati Reddy Supra, has, mm, uh, deciding, people. Had observed that a voter in a particular panchayat cannot be rendered remedialess if he is aggrieved by an by election of a candidate to the office of the panchayat. If such candidate is disqualified on the premise that, and cannot be rendered remedialess. If he is aggrieved by the election of a candidate to an office of the panchayat, and if the statutory provisions of the Panchayat concerned Panchayat Act and the rules prevents him from filing an election petition to challenge the election of such a candidate, a remedy is open for him to such a voter to prefer a writ petition. First, the question still remains as regards the time when such a writ petition can be entered into. Anything?
Can I add
Yes, what is the decision?
that 2018 6 SCC 162.
18/6. This is a longer decision.
This is the
Ah.
Lordship would see page. That this is the offshoot of the same very judgment, though it has been reflected in an earlier edition. Page 167, Milord.
Paragraphs, or you have
Para
seen,
3
okay,
last.
167, okay, you have compared,
Yes,
okay,
para 3, your Lordship, the last part would see
3,
the prayer that has been made and that in the writ petition. So in the earlier judgment, this prayer has not been quoted.
Kuaranto,
Yes. So timing would be crucial
ah,
because not a non-voter, non-candidate cannot challenge nomination because at that point of time there is no selection or election or he has been. Quo warranto can only be pursued when the person acquires the post, and it is on the validity of that, because there also the locus is diluted, because quo warranto can be filed by anybody because that the public authority. So when election petition is filed, it is locus of the candidate is there qua the candidate. But so far as locus in a quo warranto is concerned, it is diluted, and on the eligibility part only that can be decided. That is my response submission.
right. No, while deliberating on those the batch of petitions, I have come across a point exactly on this point. Kuaranto. Whether I referred, I forgot. Because only Kuaranto is maintainable. Somewhere okay. There. তাই ডুবে তাত লিখিব। A subsequent decision titled Bharati Reddy versus State of Karnataka and others, reported in 2018, 6 SCC 162, comma, which arose out of the previous decision in Bharati Reddy Supra 2018 12 SCC 61 has been placed before the court, has been placed before this court. What High Court did in the thereafter, after relegation, para.
There are 12 starting, Lord. There are 12 reverting. to
After the first round,
Yes, para 12 it starts.
reverting to the remanded repetition. From the subsequent decision in Bharati Reddy, there's two Koridibo, Supra. It transpires that after the remand, the repetition was heard by the learned single judge, by a learned single judge. On merits of the controversy for grant of reliefs prayed in the writ petition, including the prayer for issuance of a writ of quo warranto. What has been held? The learned signatures allow the writ petition in part. By declaring the appellant, by declaring the proceedings by quashing the proceedings by which the appellant, who was respondent number 6 therein, . proceedings, passing the proceedings. Whereby the appellant who was the respondent number 6 therein, comma, was declared as Adhyaksha of the Zila Parishad. So accordingly, a quorum was issued to the appellant to vacate the office of the Adhyaksha of the Zila Parishad. But the rest of the prayers were rejected. The division bench thereafter affirmed the conclusion of the learned single judge, both on factual and legal matters. Then what happened?
Subsequently, the apex court set aside the judgment because there was a caste certificate, that issue was not decided.
The moot question which arose before the Honorable Supreme Court was whether the High Court, in the facts of the case, was justified in invoking its extraordinary jurisdiction to issue a writ of quo warranto. Full stop. The Honorable Supreme Court, after hearing, had allowed the writ petition preferred by the appellant. Full stop. The subsequent decision in Bharati Reddy 2 Supra is not of much consequence to the issue involved in the present batch of issue. First stop. Para. A constitution bench article T29 of the Constitution corresponds to Article 243O of the Constitution, first of Clause B of Article 329. Clause 320, Article 329 of the Constitution is also with a non-obstante clause like Article 243O, as per Clause B of Article 329, no election to either House of Parliament, huh? লিখে দিব। Para. Before a sixth judge bench of the Honorable Supreme Court in NP Ponuswamy versus returning officer Namakal constituency and others, reported in 1952, 1 SSC 1994. The question arose, huh? A question arose before a sixth judge. That whether the law of elections contemplates that there should be two attacks on matters connected with election proceedings, one while they are going on by invoking the extraordinary jurisdiction of the High Court under Article 226 of the Constitution, and another after they have been completed by means of an election petition. First off, the question was considered in the context of the provisions of Part 15 of the Constitution and the Representation of the People Act 1951. 50 or 51 asylum. $51. After examining the question, the Honorable Supreme Court has observed that any matter which is the effect of vitiating an election should be brought up only at the appropriate stage in an appropriate manner before a special tribunal, and should not be brought up at an intermediate stage before any court. While deciding, the Honorable Supreme Court has considered the meaning of the word quote unquote appearing in Article 329 within bracket B, both in a wide manner and in a narrow manner. Stop. It has been observed that in the narrow sense, the word quote unquote election is used to mean the final selection of a candidate, which may embrace the result of the poll when there is polling or a particular candidate, Mr. Ahmed, being unopposed, being returned unopposed when there is no poll. Because of a limitation, I am saying to you. In the wide sense, the word quote unquote election is used to connote the entire process, culminating in a candidate being declared elected. Full stop. The word election has been used in the Constitution in the wide sense, that is, comma, to connote the entire procedure to be gone through to return a candidate has been used in part of 15, Roman 15 of the Constitution, in the wide sense, to connote the procedure to be gone through to return a candidate to the legislature. First of, in the similar, by similar or analogy, comma, the word quote unquote election appearing in Article 243 OB and Section 129B of the Constitution and Section 129B of the Assam Panchayat Act. Comma, in the wide sense, comma, is used to connote, can be said to be the entire process right from the declaration of election till the declaration of return of a candidate as elected to a to the panchayats at any of the 3 levels. Full stop. The Honorable Supreme Court had also considered the aspect centering around the meaning of the words quote unquote, no election shall be called in question except by an election petition, unquote, in Article 329 within bracket B, and considered the point, and had stated that, had observed that the point to be decided was whether the questioning the action of the returning officer in rejecting a nomination paper can be said to be comprehended within the words, comma, quote unquote, no election shall be called in question, unquote. This is the exact issue.
Yes.
We'll come back.
Item number 13 and 16 to be taken up next week, my lord. I have second concern. Both are even. 13
You are for respondent?
my lord.
13?
And 16, my lord.
Okay, on the prayer of Mr. S. Bodal, Learned Counsel for the respondent number 4. The case stands adjourned for a week. It is submitted that counsel has been taken from the Learned
But
Counsel
where-
for the
where-
petition and the other respondents to make the prayer. 16. For the petitioner or respondent,
Responded money. My petitioner is there, my fund is there.
your state GMDA?
GMC also. GMC and GMC.
Okay,
I favor.
okay. Mr. S. Bodal, same standing counsel,
GMC.
GMC stroke GMDA. For a week, Mr.
M.K. Mujumdar.
M.K. Mazumdar, Learned Counsel for the petitioners, who is present, has submitted that, has consented to the said prayer.
Omlai. If you see any road.
As regards item number 1,
Yes,
so may not like to take up the matter.
okay.
Yeah.
Please the case before any other events without me.
Hello.
Good judgment, good. Hmm? Oh. Swami. Aspect centering around the meaning of the word humiliation shall be. Hmm. Continue. The appellant's case in N.P. Punuswamy Supra was that questioning something which had happened before a candidate was declared elected was not the same thing as questioning an election. Full stop. The Honorable Supreme Court has, in the above context, has observed as under paragraph 15. Paragraph 15. Then paragraph 25. Paragraph 29. The Honorable Supreme Court, Professor Diko, and Punuswamy has observed that where a liable right or liability has resorted to the principle that where a right or liability is created by a statute which gives a special remedy for enforcing it, the remedy provided by that statute only must be availed of. Full stop. It is held to be a reasonable view that Article 329 covers all electoral matters. Electoral matters to quote unquote. Full stop. The negative language in the form of non-obstante clause used in Article 329B has also been considered. First of it has been observed that Article 329B is primarily intended to exclude or oust the jurisdiction of all courts in regard to electoral matters and to lay down the only mode in which an election could be challenged. Full stop. It has been further observed that it is the duty of the returning officer to scrutinize the nomination papers to ensure that they comply with the requirements of the Act and decide all objections which may be made to any nomination. Full stop. This duty is to be discharged properly. Full stop. Otherwise, any number of candidates may stand for election without complying with the provisions of the statute, and a great deal of confusion may ensue. Full stop. Scrutiny of nomination papers is only a stage, though an important stage, in the election process. It is one of the essential duties to be performed before the election can be completed, and anything done towards the completion of the election proceeding can by no stretch of reasoning be described as questioning the election. Full stop. On the construction of the like the Honorable Supreme Court has also affirmed the decisions of 8 high courts that they have no jurisdiction under Article 226 of the Constitution to entertain petitions regarding the improper rejection of nomination papers by affirming the decision. First of para, the observations made and finding reached in NP Punuswamy Supra by the 6th judge with regard to 329B applies, in the considered view of this court, proprio rigore, in respect of Article 243 OB, read with Section 129 of the Constitution, read with Section 129B of the Assam Panchayat Act. Full stop. Para. The decision in NP Punuswamy came to be considered by another constitution bench of the Honorable Supreme Court in Mohinder Singh Gill and another versus the Chief Election Commissioner of New Delhi, rendered in respect of Article 329B, and Article 226 of the Constitution of India, was considered by another constitution bench of the Honorable Supreme Court of India in Mohinder Singh Gill versus so. Full stop. The constitution bench has observed as under. Paragraph 30. A coordinate bench coordinate bench to football. This is coordinate bench to football. What is the citation, Mr. Dubey?
2019 1 G.
The issue raised in a bunch of writ petition in Lily Sharma and others versus State of Assam and others Supra relates to rejection of nominations of the petitioners for contesting the ensuing Panchayat election in the state of Assam. Post of prayers were made for quashing of such rejections of nomination papers and for directing the respondents to allow the petitioners to contest the Panchayat election by treating their nominations as valid. Post of the court framed two issues which arose for consideration in the said batch of writ petition. Following three issues. Para 20. 1 to 3. The meaning of the expression quote unquote election has already been deliberated both in the narrower sense and in the broader sense. Has already been deliberated above, both in the narrower sense and the broader sense. And is not required to be dilated upon. Also, insofar as the other two issues are concerned, the coordinate bench, after a survey, after a detailed survey of the decisions in Ponusami Supra, Mohinder Singh Gill Supra, and Indrajit Borua, Bodullah, Anurag Narayan Singh, Election Commission of India, Pradut Bordoloi, Monda Jagannath, Pratap Mehta, Saji Joseph, has answered the issues in the following words. Para 45, 46. 47, 47.1. It is subtle that the right to elect, comma, to be elected, and to dispute an election are neither fundamental rights nor common law rights, but are simply statutory rights and therefore are subject to statutory limitations. So stop. Similarly, an election petition is not an action at common law, nor in equity, but is a statutory proceedings to which only statutory rules apply. Full stop. It is also tried to observe that if a person is disqualified on the date of nomination, he cannot be chosen as a candidate under the provisions of Part 9 of the Constitution of India, Constitution, and the Assam Panchayat Act, more particularly Section 111 thereof. Full stop. The disqualification which subsists on the date of filing nomination does not cease to subsist on the day the candidate is elected. And the disqualification cannot be wiped out retrospectively. Full stop. Be that as it may. Para. The observations, the observations having considered the restrictions imposed in Article 329B, 243 OB of the Constitution and Section 129B of the Assam Panchayat Act, and the fact situation obtaining in the cases in and as regards acceptance or rejection of the nomination papers of the petitioners or the respondents impleaded in this batch of writ petitions, as the case may be, comma, this court fully subscribe to the observations made by the coordinate bench in Lily Sarma Supra. Full stop. Para. In paragraph 45 to 47, in the aforequoted paragraphs, huh? Full stop. Para. The all these petitions, all the three petitions pertain to the first phase of the Panchayat election 2025. Full stop. The date of polling for the first phase of Panchayat election is scheduled on 2/5/2025. And the date of counting is scheduled on 11/5/2025. Full stop. Meaning thereby, comma, the date of polling is hardly 2 days. 2 days. Hardly 2 days away. Full stop. Intervention of the process of election at this stage would cause a number of administrative and other problems for a state election commission before apart from clouding the minds of the electorate populace. First of the rights of the petitioners in neither the rights of the petitioners in W1 item 20 and item 22 nor the right of the petitioner in 2021 and 22 have been extinguished, would extinguish to challenge, to challenge the acceptance of the nomination paper, concerned nomination papers of the rival contesting candidates or to or non-acceptance of the nomination of his nomination papers in 22 would be extinguished if in the event of, would be extinguished. Post of on the other hand, comma, if the repetitions are not entertained. Post of on the other hand, entertaining the repetition would not be in the best interest of a free and fair panchayat election. Full stop. Thus, comma, this court is of the unhesitant view that the writ petitions are not to be entertained for the reasons mentioned here in above. In view of the restrictions placed in Article 243 OB and of the Constitution and Section 129 B of the Assam Panchayat Act. Therefore, no. Full stop. It is accordingly observed. Non-entertainment of the writ petition shall not, however, preclude the petitioners to avail their remedy under Section 243 OB of the Constitution and Section 129B of the Assam Panchayat Act by filing election petitions. Sorry. Sorry. Other than the petition number 1 in 20, the other petitioners would not be precluded from filing election petitions before the jurisdictional Panchayat Election Tribunal within the stipulated period of limitation after declaration of the results. Full stop. Insofar as the petition number 1 in 20 is concerned, he can explore the possibility of filing a writ petition only after declaration of the results of the with regard to respond number 6 or 5.
In my side. No, 1. I don't want the after.
If in the if after declaration of the results, Panchayat, the respondent number 6 gets elected, having limited within the limited scope as observed in, what is the name of the decision?
Yeah.
Bharti Reddy. Supra. With the not entertaining.
Rejection order for my friend.
Huh?
That rejection order.
Insofar as the grievance of the petitioner in 22 is concerned, insofar as the grievance of the petitioner in 22, that he has not been informed the reason for rejection of his nomination paper is concerned, comma, it is directed that the authorized official appointed under Rule 22 of the Assam Panchayat Constitution Rules 1995 shall furnish the reason to the petitioner within a period of 7 days from the date of submission of a certified copy of this order to him by the petitioner.
Our
He
election,
knows the reason.
our election will be held on second phase, 7,
Second,
not 7.
7th.
Item 22, our election will be held. on
I asked you,
Second
I
phase,
did-
second phase.
I asked you, you said first phase.
No. The first phase, Mr.
See,
Not responded.
not responded. I asked you, everybody, so as to construct my order.
Because you have clearly indicated that all these 2 days are left, my lord.
Now you are saying.
I am not.
I asked you for the first, all are in the first phase or second phase? You said first phase.
No, second phase. I'm sorry. I actually, you're lots of dictating. That is why I am
Second
not.
phase. As first repetition, first phase, third repetition, second phase. 2-5 and 7-5. 2 days and 9 days दी है तो हिसाब कोई भी. Anything left which was argued?
Please, your lordship. My lord, claims and counterclaims in respect of a piece of land. One round has already gone in this court. This court gave some directions to the DC to demarcate the land and cause an inquiry because it was all under attachments. So that process is on. So the petitioner also owns some of this one part of the land. So she is also part of it now. And meanwhile, a civil suit has been filed by the respondent for declaration and title. And she has yet to appear there. But the court, civil court has directed the circle officer to submit his report, which was directed by this court earlier, within 2 months. That your lordship will find at page 137. 137 only.
Suit is between whom? Okay, petitioner is a defendant.
Yes.
Petitioner is a defendant.
Yes, sir.
This is suit for his
This
fault.
is order is at page 137, 20th February 25. My lord, the operative person for the circle officer is at page 138. The last paragraph is accordingly a communication dated 18 to 25 has been made to the circle officer of the school revision to conduct a detailed inspection over the scheduled plot of land and to comply with the Honorable High Court's order in WPC 6589 and IA in 2979 of 19 and submit a report to the District Commissioner Kamrup within 2 months. So that will
What is the order?
20th February
That
2025.
read petition order?
Writ petitioner order is earlier, Milord, in point of time.
What is in compliance?
This is first order was
29.
26/6/19.
6589 2013 read petition
81 page.
Page 1,
80.
81.
1. This is between Pranavjyoti and there the petitioner was not a party. Petitioner was not a party there. Huh? Not a party.
Initially, she was not a party. Then
Later on.
Later on, she came. But in
What
the-
is the
in the final
observation?
hearing, she was unrepresented.
What is the
Yeah.
observation? Directions.
Direction of the learned judge in that proceeding is at page 85, Milord.
85.
And subsequently, when we came to
Shall
know.
be
and
custodian
filed an
of land
application,
at its-
that
what
is
is
at
this?
page 115.
Huh?
85, several
Several directions.
directions,
Huh.
mainly Milord for inspection, measurement, demarcation of
Hmm.
the claimed lands on the part of the persons concerned. So that process is on. The deputy commissioner was directed to do it through his subordinates. The circle officer was in the process. And now the last order of the civil court is, I have shown,
Yes.
it says that submit your inspection report within 2 months, which
Huh.
will mean, and then just fix the matter on 5/5. And therefore, he is supposed to file that within that so that the matter can be taken up on 5/5. What he has done is, Milord,
This is purely with respect to Pataland.
Pataland.
Huh?
Pataland, and it's a very interesting
Huh.
situation.
Pataland.
Pataland.
Then what circle officer has to do?
Milord, what has happened is, that is pursuant to the directions given by this court.
Who is the impugn notice?
120, 120, Milord.
120.
Yes, it actually starts at 119
I'll read the
And the-
vernacular itself.
and original is at 120.
I'll read the original.
Yes, please.
Yes, Mr. Hendrik, if it is Pataland, there is a title, so what circle officer has to do? Bedokhol Mukto. Is
He
it
has
not a
to-
decree?
No, no,
He is not executing a decree perhaps.
No, no, no.
Huh?
He is required to submit his inspection report. So he is passing an eviction order.
Patar, periodic pata appears.
Yes, yes.
Huh?
Yeah.
He is not under any execution, he is
No,
not
no,
executing a
nothing,
decree.
nothing.
It is done, my lord, as per the direction of the Sonarpur court as well as the.
What direction?
Lordship, may kindly see the page 85.
Whether court has given him direction to Bedokhol Mukto?
No, my lord.
No, no,
Then-
no, no,
That's
no.
inspected.
It is only
Then-
for demarcation. No.
Heard Mr. P.K. Goswami, Learned Senior Counsel, stated by Mr. M.K. Das, Learned Counsel for the petitioner. Uh, Ms. P.R. Mohanto, Learned Standing Counsel. Revenue Department for the respondent number 1. Mr. J. Hendrik, Learned Junior Government Advocate Assam for the respondent number 2 and 3. Post of the petitioner has approached the court by registering its petition to a sale and notice dated 23/04/2025 issued by the respondent number 3 on the subject quote unquote notice to vacate land. Post of in the notice, the respondent number 3, respondent number 3 question hai kote? Has referred to a parcel of land covered by Dag number 618/1 1567 stroke 1527 within bracket new and patta number 120 stroke 307 stroke 98 within bracket new, comma, situated
That is the
at
difference.
village Haukusi,
Hmm?
comma, Mauja Beltola
My
district,
response is here.
Kamrup Metropolitan District. Within bracket, the subject line for short. Poster. The response number 3 by the impugned notice has directed the petitioner to vacate the subject plot
By 38.
on the ground that the petitioner is in unauthorized occupation of the subject
Very
plot.
position.
Poster. By the notice, comma, the petitioner has been informed that if the petitioner does not vacate the subject land, then appropriate proceedings would be drawn on 34/2025 under the Assam Land and Revenue Regulation
For eviction.
for eviction of the petitioner. Post of Mr. Goswami and Senior Counsel for the petitioner has appearing for the petitioner has submitted that the subject land is
I'm first questioning. No, beautiful.
in respect of the subject land, comma, a title suit, comma, title suit number 468 of 2016 is presently pending before the Court of Learned Civil Judge number 1 at Guwahati, wherein the petitioner is the defendant number 1.
Number 2, civil judge number 2.
Okay, number 2. Okay.
Senior division.
Wherein the petitioner is the defendant number 1. And full stop. The suit has been instituted by the respondent number
4 and 5.
4 and 5 herein for declaration of right, title, and interest over the
Here don't fully.
subject land and seeking ejectment of the defendants, including the petitioner herein. Full stop. In the Mr. Goswami has further submitted that in the sixth title suit, comma, the learned court on 20/02/2025 has passed an order directing the respondent number 3 to conduct a detailed inspection over the scheduled plot of land within bracket, that is the subject plot, and to comply with the directions of this court passed in WPC number 6589/2023 and IS civil number 2979/2019, which is 138 and to submit a report to the respondent number 2 herein within 2 months. Full stop. As the respondent number 3 has never been directed to initiate any proceeding to vacate the subject land from the alleged unauthorized occupation of the petitioner. The impugned notice dated 23/4/2025 is without jurisdiction. Full stop. Para. Privacy, comma, the subject land is a periodic patta land. Full stop. the lease in respect of the subject land is presently pending before the a civil court in title suit number issue notice returnable in 4 weeks as so and so has appeared, accepted notice, issuance of formal notice dispensed with. The petitioner shall take steps for service of notice upon the response number 4 and 5 by registered post UTID within 2 working days from today. Privacy, comma, the subject land is a colon, a lease is pending. And a lease is pending before the civil court in the form of a title suit, comma, title suit number so and so. And the title suit has not reached a finality, meaning thereby the response number 3 is not executing any decree of the civil court. Full stop. As such, comma, the response number 3 primacy does not have any authority and jurisdiction to initiate any proceeding under Assam Land and Revenue Regulations in respect of a periodic pata land. In such view of the matter, it is provided in the interim that the operation of the impugn notice dated so and so
23/4/25.
shall remain suspended till the returnable date. Meaning thereby, there shall not be any eviction proceeding in terms of the notice dated so and so.
For admission, item number 2,
Mr. Chaudhary is also instructing us.
Huh?
Nihal Chaudhary, he is also instructing us.
Assisted by Mr. Bhidiva Chaudhary.
Biplab.
ID.
I demand that matter. Now, my lord, we have filed an affidavit. Now, here, IIT had filed an affidavit. They say, my lord, that we are the beneficiary. We have nothing to do. Now, we are a society. Now, if some money is required to be paid, then it has to be paid by, my lord, the central government, Ministry of Education. And then, my lord, we filed an affidavit. And then, my lord, CGSE also was directed to take instructions. And they say, my lord, that whatever they have, they do not have the information as to how much amount was given and how we have spent it and how we have utilized it. To that extent, my lord, we have filed an additional affidavit, bringing on record, my lord, whatever money we had received, whatever we have spent in relating to each one of the particular, my lord, cases, land acquisition case and, my lord, money execution case.
Did you send
Yes, now we have
them
yes,
or not?
we have already sent also. Then again, my lord, they say, my lord, that it may not be an utilization certificate in the proper format. Then again, we have, my lord, send the utilization certificate. Now it is under that state of affairs, my lord, that the matter stands. In the meantime, of course, my lord, in the writ proceeding, I cannot, although we have challenged the money execution proceeding, but it is only for namesake. I have to be fair to the court.
So that is already closed.
So
I think it is observed that
yes,
we are not
yes.
looking
Now,
into that money execution
yes,
process.
now it has gone to that stage, even, my lord, that writ of attachment was issued. And the office of the Deputy Commissioner at Amingao was about to be, my lord, seized and, my lord, and my lord, attached. At that stage, my lord, we had diverted funds of amounting to almost 1 crore from other head of account. And somehow paid for the timing, my lord, in relation to that execution cases. Then thereafter, again, my lord, a sum of 50 lakhs have been diverted from other account, and then again it is paid. Still, my lord, substantial amount of outstanding is pending. Now, we are trying to comply with each and every, my lord, requirement that the central government is seeking. This is how, my lord, the state of affairs now stands. Now, off late, my lord, this utilization certificate has also been, my lord, transmitted to the central government. I have shared a copy with my learned colleague, soft copy, so as to give them an advance notice of these facts.
They have sent down 741 letter as per direction of the Honorable Court. Honorable directed on 13/3/2025, my lord, to give to forwarded the utilization certificate, and they send it on 7/4/2025, my lord. After it April 25 for my lord, that last Friday they have. So I require some time to take instruction. I have already talked with that ministry, my lord. So we require some because on Friday evening they have sent this letter, my lord, utilization certificate.
Madam, I think it is Land Acquisition Act 1894.
Yes.
1892.
Deputy Commissioner acts as the land acquisition officer,
Yes. Yes, ma'am.
right? And he has acquired the land on behalf of the Indian government for Indian government. He acts as an agent of the Indian government. Right? What he has done, he has not done whatever. He makes the offer as a land acquisition officer to the affected landowner by making the award. Right? Award is not the finality, it is an offer only. The landowners may accept, may not accept. They may go for reference under section 18 or section 30. And everything crystallizes only after a reference order. Right? So reference order attains the, it is the final position. Whatever has been passed has attained finality. Right? You have not challenged that. Now he is on all throughout the process. He acts as your agent. Right? The reference court has passed the award. As a result, 4 crore something
Yes.
has resulted, which is payable now.
Yes, that is payable.
And that is a liability of the acquiring authority. And you are the acquiring authority. And it is you who has to comply with the order of the reference court.
Reference code, we are not the party before the reference code, my lord. We are not the, we don't have any idea about the case because.
You are not challenging as of now.
Not challenging, my lord.
Are you challenging? When the reference order was passed?
Take, my lord.
Long back,
2005.
2005.
They utilization certificate only on 7/4.
File an appeal with
7/4.
4,000 days delay of condemnation.
So, my lord, yesterday only I talked with that ministry, my lord. So they received, I have sent this letter also through mail because he gave me on Friday evening, my lord.
Hmm.
So request some time to what extent we can go through, my lord. But that is my.
So tentative view of the court is that he is an agent.
So because my lord,
Why state of Assam? What role state of Assam has?
State of Assam,
Huh?
my lord, Deputy Commissioner is also the petitioner.
He is an officer of the state government. But find out the provision, say in National Highway Act, if it is the Union government, competent authority is appointed under Section 3A, right? So in case of acquisition of land for national highway, the additional deputy commissioner or competent authority is not an officer of the state government. He acts as an authority under the central government. Now, likewise, whether in the LA Act, the deputy commissioner is appointed as a land acquisition officer by the central government. What is the provision?
No, Deputy Commissioner, he is the collector, he is the acquiring authority.
Right, he is the acquiring authority. He makes the offer. But because the acquiring authority is the central government for IIT.
Yes, that is the requiring authority.
Huh?
They require the part and parcel of land. And my lord, under the scheme of land.
That is what I am
Yes,
asking you.
yes.
One is requiring authority. One is acquiring authority.
I am the acquiring authority.
Huh?
The collector, that is the deputy commissioner. is the
There
acquiring
may be subtle change.
Yes,
Because this land of IIT belongs to whom now?
no, land of IIT, it has been acquired and now given to them.
No, who is the owner?
Owner will be, my lord, the IIT.
Ah.
IIT, because that is a society registered. They say they are a registered society. I acquire land from the landholder.
So land vests in whom?
Land based with IIT.
Then
So therefore now.
whether
Yes. So now. Yes.
you as a land acquisition officer, I am asking that just
Yes,
don't
yes,
answer in haste.
Yes.
Because question is ultimately land vests in whom? So the way you act as a land acquisition officer under the state government, if the land based in state government, and the way you act as a land acquisition officer in respect of land which ultimately would vest in the central government are two different things.
Absolutely. Absolutely. So therefore, my lord.
But why you did not bring this Union government when the reference was made against you?
Because under the scheme of the, my lord, Land Acquisition Act, my lord, it is for them to challenge.
Who?
Because, my lord, the requiring authority. Because the reference was instituted by.
No, why did not you bring them in? That I am not the person to be prosecuted.
In fact, my lord, that application was also made, and the IIT challenged it, and there is a judgment of this honorable court. I have not got it, my
So,
lord,
madam,
whereby IIT has been, my lord, their names have been struck off. Their names have been struck off, my lord.
yes, madam. So when can you expect?
I will bring the law. I will place the law, because today I'm not prepared to that extent, my lord. I will
No, find out that there may be subtle change. This is my intuition.
Lordship is absolutely correct. Lordship will kindly perceive the
Land Acquisition Act.
Yes. Kindly perceive the situation.
Land Acquisition Act.
Land is owned by the pattadars. They are the registered pattadars. Now, once the land is acquired, my lord, their names are striked out from the patta. Then whose names comes in, my lord? The one who.
Now you are submitting after my query.
No, my lord, this is the scheme under the, my lord, the act itself, my lord. I will show it, my lord. And listen. Lordship will kindly take up my lord section 6.
Where is a reference to land acquisition officer?
Yes, my lord, that is section 18, my lord.
Hmm?
Section 18 is reference to court.
Hmm? No, what is, how the deputy commission is described?
Yes, my lord, that lordship will find it in the definition first, my lord. That-
I have seen the definition. After that, I'm asking you. Where is that? Collector,
Collector, my lord.
collector.
Yes,
Ah.
C. 2C. 3C,
C.
my 3C.
C now,
Yes.
section 3C,
3C.
read with section 3EE.
3EE. Yes. C says expression collector means the collector of a district and it includes a deputy commissioner and any officer specially appointed by the appropriate government to perform the functions of a collector under.
Now
this-
3EE.
Yes. EE, my lord.
My
The-
query appears to be privacy correct.
EE, my lord, defines appropriate
E3.
government. The expression appropriate government means in relation to acquisition of land for the purposes of the union, the central government, and in relation to acquisition of land for any other purpose, the state government.
Then, for all these years, what you are doing? This deputy commissioner is not an agent of the appropriate state government anywhere. He is an agent of the central government.
Central government.
Your master is disobeying you. They are not coming to your rescue, perhaps. You are not an, your petition also. Why state government?
Now,
There is no question state government entering into the arena. Is it not?
yes, correct.
Huh?
Yes.
And this petition is prepared by state government.
State government is one of the petitioner. Collector is there.
They should know where be in the scene.
No, but collector is here.
Hmm?
Collector is
He is
the
a
petitioner.
collector, but he is collector stepping in
But
inside the umbrella of central government.
yes, but here what has happened, lordship is correct. Under the scheme of this act, my lord.
Okay,
appropriate-
petition is maintainable so far as petition number 2 is concerned.
Yeah, two is concerned. Now, my lord, if we go by the
Yes,
fact-
madam, now this is the position.
Now, my lord, here,
Read with section so and so,
My lord,
he is an agent.
why, with all respect, why I have made that submission here, the section 6 notification was issued by the state government. Although appropriate government ought to have been central government as per 3EE, lordship is absolutely correct. But the state of affairs of this particular case is such, my lord, that here section 4 notification as well as section 6.
No, no, sir, it can, there may be a provision that appropriate government power is also delegated to the state government, perhaps, to issue notification. It might be there.
It has to be there, my lord.
If I,
So this is how, my lord, the matter stands.
yes, otherwise, he is acquiring for you. This is a position, not for state government. You are the owner of that particular land, or maybe after acquiring, you have transferred it to the IIT. But you are the owner. After award, and after finality of the award by the reference court, the land vested in you ultimately. And this man is facing execution proceeding.
And the education proceeding, that is true, they are facing the education proceeding, but neither we are the party in reference nor that.
But he's an agent.
But my lord, they didn't.
He's an agent for you.
Case number 120, my lord, we have sent a letter to the state government. To the deputy.
No,
commissioner.
if this proposition is correct, that he is an agent
That is.
of the central government,
Yes,
then all other things will fall by the wayside. Page?
is 120, my lord.
Then a mandamus may be called for.
My lord. Page 120 on letter dated 19th August 2019.
What is it saying?
19, we ask some in last paragraph, my lord. In view of the above, the state government may settle the issue concerned with the IT by provide follow. That document has not been sent. They have sent their documents on in 2025 only.
No, yes.
That
Now,
is- yes, my lord.
this issue never cropped up.
This issue,
No. Deputy Commissioner acting as an officer of the central government. Then no question of state government. You find out that provision, if there's something is delegated to the state government,
yes,
that act of the state government is an act of the central government. That
Now-
cleanses the issue, then there is nothing to be decided thereafter. Deputy Commissioner's position is clear now. Now find out the provision whereby power is delegated to the state government to act on behalf of the central government.
central government.
Like PWD state for acquiring land for national highway.
Highway. Yes, yes,
Have you got the,
yes,
this is the connection. If the central government
Hmm.
delegates the power to the state government, then any act of the state government under the delegated power is an act of the central government.
absolutely.
Then all these issues are not to be,
That is one aspect of the matter, but
not one aspect, then we can issue mandamus.
therefore,
Not one aspect. That is a single aspect.
now Lordship.
If
just-
you can show it,
Hmm.
then all these acts of the central government, not on absence of the central government before the referral court cannot be a ground
It cannot be a ground.
if Deputy Commissioner is an agent of the central government. Then all these execution proceedings should be diverted towards the central government.
But it should be absolutely.
Right.
There are decisions I will
So
place.
please
Yes, yes,
find out that
Yes.
central government has delegated the power
my lord.
to the state government under the LA Act 1894 to issue the notification under section 4 and to issue the declaration under section 6.
Yes,
If those are there, then all these acts are of the central government. Then nothing will survive in the mouth of the central government.
yes. Yes. I'm so grateful, man. Yes,
Deputy Commissioner clear now.
yes,
Only thing is that 4 and 6.
4
If
and
power is delegated, all these are acts of the. And utilization certificate, then they will decide internally.
yes, my lord, that will become then redundant.
That will be decided internally.
Yes.
Utilization, all
Yes,
these,
yes,
they
yes.
will write letters,
Absolutely.
thousands of letters, interdepartmental communication. Madam, you find out otherwise, you will be in serious trouble. He is an officer of yours. Right?
I'll find out that also, my observation on the court, my lord. I'll find that on.
Which one?
The delegate.
No, it is the LA Act only. Section 3C and Section 3E. Not an observation of the court.
Yes. And regarding that later, my lord, they have planned on the 25 court. I'll take it. I have already talked with the talk has been made, my lord.
How much is payable? 4 crore?
4 crores 63 lakhs. Now it is, my lord, increasing. 4 crores 63 lakhs, my lord. Way back in the year 2019, in fact. prior
Take
to
the
that-
instruction.
I'll take instruction on that. my lord.
You also take instruction,
Yes,
4 and
absolutely,
6.
Absolutely. my
I heard Mr. R. Borbuzai, Learned Counsel for the petitioner. And Miss A. Gayon, Learned Central Government Counsel for the
Respondent number
Respondent number
6, ma'am.
6.
Respondent number 6, yes, ma'am.
6, my lord.
Also heard Mr. ABD for the respondent number 7. Mr. SD Purakash for the land council for the respondent number 1 to 3. Mr. A Deka for the land council for the respondent number 4 and 5. Full stop. Para. The subject matter of this, the genesis of this writ petition is an acquisition process initiated, land acquisition process initiated for the purpose of acquiring land to establish the Indian Institute of Technology in Kamrup Rural District.
Rural, Kamrup rural. At that time it was Kamrup, now Kamrup rural.
Okay, Indian Institute of
Notable
Technology,
point
Guwahati.
Kamrup.
Full stop.
Yes, yes, I think.
Para, the land acquisition officer. The land acquisition proceeding was initiated under the provisions of the Land Acquisition Act 1894, since within brackets since repealed. Full stop. The Deputy Commissioner Kamrup Amingao was the land acquisition officer for the said land acquisition process. Full stop. It primarily appears that the land acquisition proceeding was initiated for the purpose of the Union government. Full stop. As per section 3C of the Act. Act for short. Collector means the collector of a district and includes a deputy commissioner and any officer specially appointed by the appropriate government to perform the functions of the collector under the Act. Full stop. As per section 3EE, small e, the expression, quote unquote, appropriate government means in relation to acquisition of land for the purposes of the union, the central government. Full stop. Para. It is brought to the notice of the court that the notification under section 4 and the declaration under section 6 of the Act were issued under the authority of the state government. Full stop. Mr. Borpujari has sought for a week's time to obtain instruction whether the state government had issued those notification and declaration under authority delegated by the Union government. Full stop. Para. MS Gayon, Learned Central Government Council, shall obtain instructions with regard to the office letter dated 19/8/2019 at page 120 of the case papers. Full stop. MS Gayon shall also is also required to address on the point. Para. And a land acquisition officer like the collector makes offer to the affected landowner, and such an offer is on behalf of the appropriate government. Full stop. Yes, what Padiola has observed? What Padiola has observed? Justice Padiola has observed. No, there is another judgment of the Honorable Justice Padiwala on the land acquisition. It is for the landowner, affected landowners or persons interested to accept or not to accept the award offered by the land acquisition officer in a land acquisition proceeding. So it is only after order passed by the in the what is it called now? Previously, now it is LARR, earlier reference code.
Reference code,
Ah,
reference
It
code.
is only after the orders passed by the reference code. After a reference under either under section 18 or section 30 of the Act, comma, the amount, compensation amount attains finality. Post up. Till that point of time, primacy, comma, till that point of time, comma, the land acquisition officer acts at the under the aegis of the appropriate government. MS Gayon is required to has sought time to address on the aforesaid aspect on the next set of listing. List the case. You will find another judgment of Honorable Justice Padiwala. How
Noted, my lord.
the Deputy Land Acquisition Officer acts, or what is the nature of the offer?
Yes, to what extent, my lord, yes. And in fact, my lord, that.
Yes, when? When, madam? We'll dispose of on the next date,
Yes.
rightly or wrongly.
May 2nd week.
Okay.
In-
On a date in the second week of May, commencing from 13th, not second week, third week,
Third week,
commencing from
yes.
13th of May.
In fact, my lord, in the reference court order, which is a part of the record, at page 41, it says notification RLA so-and-so published in initial 4, and that declaration so-and-so published in the Assam Gazette. That means state government. Now I will take
Oh,
the,
Find out from the
absolutely,
that
absolutely.
PWD
Right.
acquires land
Yes,
for central government for national highway. How?
Date,
On a date in the week commencing from 13th,
Mana 16.
any day, race will decide. Any day, you prepare on any day.
Mana 13 or nothing, on 16th of May.
I have said already twice.
Sorry, my lord. Sorry,
I'm so grateful.
Item 3.
Find out that aspect.
Yes, yes.
4 and 6. If it is delegated, end of the matter. Yes.
Need to your lordship. My lord, the primary order which has been challenged in this writ petition is an order by the Deputy Commissioner, my lord, which has held that the land acquisition proceedings, two proceedings initiated in 2011, that has to be decided on the basis of the new act, 2015. May I take your lordship to the impugned order first, my lord? Then I'll give your lordship the backgrounds. The impugned order, there are two orders. One is at my lord, page 155, annexure 32.
155.
155.
This is the impugned order.
This is the impugned order, one of the impugned orders. It's a long order, but I need to read it because, my lord, there has been other litigations earlier. May I read it, my page 155.
Yes.
Since the judgment and order dated 2/3/2023 passed by the Honorable Guwahati High Court in WPC 7797 of 2017.
It is available in which page?
My lord, this order.
Just name the page.
List of days of Honorable.
Part of the petition,
Yes, my
page
I do. 2/3/2023.
140. Okay, okay.
Whereas Oil India Limited Duliajan was given the authority to enter upon to carry operation upon 56.83 bighas of land of Pukanpukri Tea Seat of Messrs. Nandalal and Sons Tea Industries Private Limited in the year 2000 under Rule 190 of ALRR 1886. Whereas in the year 2002, the Tea Garden authorities filed 4 writ petitions, numbers such and such, before the Honorable Guwahati High Court claiming adequate compensation for deprivation of its rights of occupancy and use of the land. Whereas the Honorable Guwahati High Court, vide the judgment and order dated 5/4/2011, passed in the 4 writ petitions number such and such, dispose of the writ petition by directing the Deputy Commissioner to initiate a process under the Land Acquisition Act 1894. That order, your lordship.
What is the page?
That, yes, my lord, 74,
74.
my lord,
Only 74.
my lord.
Begins at 77.
Earlier was 140. Okay,
Yes, ma'am.
74. Okay.
And consequently, Deputy Commissioner Tinsukia initiated the land acquisition process against 56.83 bighas of land under LA Act number 1884 by LA case number 192 of 11 and 193 of 11. Whereas thereafter the Deputy Commissioner Tinsukia fixed the overall gross value of land at rupees 10 lakhs and odd per bigha. Then market value, this calculation, total 10 lakhs 7,872 per bigha. Whereas the Deputy Commissioner Tinsukia, wide later dated 16th July 2011, requested Oil India Limited to deposit the amount of rupees 5,90,000 and odd against LA case number 192 and 39 lakhs and odd in LA case number 193 of 2011. Whereas Oil India Limited challenged the above request of the Deputy Commissioner Tinsukia in the Honorable High Court by WPC number 5372 of 2013, and the Tea Garden authorities being deprived of the compensation approached the Honorable Guwahati High Court by WPC 587 of 2017. Whereas the Honorable Guwahati High Court, by order dated 8/7/2017, passed in 108, Annex 6. 110, man. By order dated 8/2/2017, passed in WPC 587, directed the Deputy Commissioner Tinsukia to pursue the LA case number 192 and 193 of 11 and bring to a conclusion. With regard to 5372 of 2013, in the same order, Honorable Guwahati High Court directed the Deputy Commissioner Tinsukia to revisit the provisions of letter that is 16/7/2011. This year lawsuit gets at page 108, Annex 16, and arrive at a proper and due compensation payable to the petitioners by following the due process of law. Whereas consequently, on 21st May 2017, Deputy Commissioner Tinsukia passed an order for proceeding the LA case number 192 and 193 of 11 as per the provisions of the Right to Fair Compensation Act 2013, that your lordship gets at page 116, Annex 20. Whereas the Deputy Commissioner 116, page 116.
21st May. Page
116.
Yes, 116.
Whereas the Deputy Commissioner Tinsukia, while later dated 15th September 2017, that your lordship gets at page 123. September 2017, submitted the award proposal of LA case number 192 and 193 of 11 to government for approval. Whereas the order dated 21st May 2017 passed by the DC Tinsukia was challenged by WPC number 7797 of 2017. Whereas the Honorable Guwahati High Court by an order dated 15/12/2017 that your lordship gets at page 131. 15/12/2017, Annexure 27, page 131, passed in WPC number 7797 of 17, state the operation of the order dated 15 September 2017 of the DC Tinsukia. Whereas tea garden authorities also filed WPC 6290 of 2017 for non-payment of compensation. Whereas both the WPC number 7797 of 17 and 6290 of 17 were decided by a common judgment and order dated 2/3/2023, page 140, Annexure 30. By common judgment and order dated 2/3/2023, where a direction was given to Deputy Commissioner Tinsukia to find out whether there exists an award which may have been made under Section 11 of the LA Act 1894, the implication thereof be followed so that the landowners receive the appropriate compensation for the land that had been acquired. And if, on the other hand, the Deputy Commissioner Tinsukia arrives at his conclusion that no award has been made under Section 11 of the LA Act 1894, the provisions of Section 24(1)(a) of the Right to Fair Compensation Act 2013 may be made applicable and the process be brought to its logical end. Whereas the provisions of the award as per Section 11 of the LA Act is as follows, that your lordship may perhaps skip, my lord. This paragraph and the next two paragraphs at page 157, your lordship may skip, my lord. But the, my lord, third paragraph I'd like to read. Whereas after going through the entire records, various orders of the Honorable Guwahati High Court and the provisions of the laid down in LA Act 1894, it is said that then Deputy Commissioner Tinsukia, while later dated 16/7/2011, fixed the value of the land, asked the oil authorities to deposit the value of compensation. Before issuing later dated 16/7/2011, government approval should have been taken as enjoined in the provisions Section 11 of the LA Act. It is evident that the proceedings of LA Act 1894 has not been completed and disposed of till date. Any amount of compensation has not been paid in respect of the said proceeding to the landowners except rupees 1.5 crore deposited in the Provident Fund account of Assam Tea Employees Provident Fund Organization as per the order dated 19/4/2018, passed by the Honorable Guwahati High Court in WPC 7797/2017. Whereas the provisions of Section 24 of the Right to Fair Compensation Act 2013 is as follows. Section 24(1), notwithstanding anything contained in this Act, in any case of land acquisition proceedings initiated under the Land Acquisition Act 1894, A, where no award under Section 11 of the said Land Acquisition Act has been made, then all provisions of this Act relating to the determination of compensation shall apply. Or B, where an award under this Section 11 has been made, then such proceedings shall continue under the provisions of the same Land Acquisition Act as if the said Act has not been repealed. Number 2, notwithstanding anything contained in subsection 1, in case of land acquisition proceedings initiated under the Land Acquisition Act 1894, where an award under such Section 11 has been made 5 years or more prior to the commencement of this Act, but the physical possession of the land has not been taken. This is important, my lord, I'll argue on this. Or the compensation has not been paid, the said proceedings shall be deemed to have lapsed, and the appropriate government, if so chosen, shall initiate the proceedings of such land acquisition afresh in accordance with the provisions of this Act. provided that where an award has been made and compensation in respect of a majority of the land holding has not been deposited in the accounts of the beneficiaries, then all beneficiaries specified in the notification for acquisition under Section 4 of the said Land Acquisition Act shall be entitled to compensation in accordance with the provisions of this Act. Whereas the proceedings in LA case number 192 of 11 and 193 of 11 are not disposed, neither any payment as ordered by the Deputy Commissioner Tinsukia has been deposited in the account of the landowners. As such, the land acquisition proceedings deemed to be lapsed after the provision of section as per the provision of Section 24 of the Right to Compensation Act and Transparency in so-and-so Act 2013. In view of the above, it is decided upon that there was no award passed in LA case number 192 and 193 of 2011 as per Section 11 of LA Act 1894. Further, LA case number 192 of 2011 and 193 of 2011 will be proceeded as per provisions of the 2013 Act to determine the compensation. Proposal to be prepared accordingly for onward submission to the Revenue and Disaster Management Department dispute. Then, my lord, the other order which is under challenge is, my lord, at page 159. 159, next page, my lord, 159. This is a communication addressed by the Collector Tinsukia to the Oil India Limited and copy and endorsed to, my lord, different authorities. Submission of revised award estimate in form number 7 under the provisions of new LA Act 2013 against LA case number 192 and 193 of 2011. With reference to the subject cited above, I would like to submit herewith the revised award estimate in form number 7 under the provisions of new LA Act 2013 in respect of LA case number 192 and 193 by the Honorable High Court Guwahati's order dated 2/3/2023 in WPC such and such linkage such and such. Oil drilling location at various Hukanpokri Tea Estate as per assessment report of land received from Circle Officer Tinsukia Revenue Circle. In this regard, revised award estimate amounting to rupees 20 crores and odd only against LA case number 192 and 1 crore 32 lakhs and odd in respect of against LA case number 193 of 2011. Total amounting to 22 crores 21 lakhs 72,794 only payable to the affected landowner submitted for. Now, my lord, before proceeding further, my lord, I'd like to bring to your lordship notice, my lord, how Oil India Limited normally, my lord, acquires the land. That procedure is important, my lord. I have stated in paragraph 7, because, my lord, we do not go for acquiring land by approaching the, my lord, Deputy Commissioner and, my lord, Section 4, Section 6, this, my lord. Before that, my lord, what we do is we take, my lord, the permission to enter into the land, right of entry. If your lordship kindly comes to paragraph 7, my lord, if your lordship permits me to read that.
Yes.
In fact, my lord, paragraph 7 to borrow. I'm sorry, my lord, it's not paragraph 7. Procedure to our message. Because, my lord, what we do, we, my lord, approach the authority, my lord, the authorities for right of entry.
I
Under
have
the, my
read
lord,
paragraph 7. I have read paragraph 7 since you took me to 7. There was some direction of the judgment and order.
my lord. The petitioner
5/4/2011.
state that challenging the validity of right of entry given to oil under the provisions of Rule 89 and 190. That is how, my lord, we approach of the Assam Land and Revenue Regulation 1886.
And
Landowners have approached this honorable court by preferring 4 writ petitions. Now, my lord, that procedure, if your lordship, my lord, finds, my lord, at page 54, we, my lord, request the deputy commissioner to grant, my lord, right of entry.
No, judgment. There you mentioned, dispose of the writ petition
Yes.
by judgment and order dated 5/4/2011, which a direction to the deputy commissioner to initiate a process under the Land Acquisition
Yes.
Act.
Now, before that, my lord, what we have done is, my lord, in 2000, 29/6/2000, my lord, your lordship will find that at page 54A, we had written to the, my lord, deputy commissioner. This is how we proceed, my lord, for acquiring. Right to entry under Rule 190 of ALRR 1886 in respect of the land involved in our proposed drilling locations, such and such. With reference to the above, we hereby apply afresh for granting us right of entry under Rule 190 of the 1886 ALRR in respect of land involved in our drilling location, such and such. In this context, we are enclosing here with the schedule of land likely to be involved in the above mentioned locations. Further, we would like to inform you that as per our prevailing practice, any existing public tree garden road required to be used by oil for its operational need is developed and maintained by oil during the period of operation. If any land acquired for widening the existing road for the above purpose, additional land is required by us. Therefore, as regards the approach road leading to our drilling location, falling within the Hukanpukri Tea Estate, we only propose the additional land garden road, which we will construct, develop and maintain during our operational period. However, the plinth as well as the small portion of the approach road in respect of our drilling so and so, my lord, in that view of the matter. Then, my lord, in view of the urgency of our oil exploration program as per MOU with the Ministry of Petroleum and Natural Gas, we request you to grant us right to entry. And then, my lord, the right of entry was granted at the next page your lordship will find.
Yes.
Then, my lord, this is important, my lord. The land was, the physical possession of the land, it was, my lord, identified, demarcated and handed over by the circle officer on 27/11/2000. That your lordship gets, my lord, at page 64. Onwards, my lord. This is handing and taking over the land involved in oil's drilling location. In pursuance of the Deputy Commissioner and Collector Tinsukia's order number such and such, the land shown in the schedule below is identified, demarcated and handed over to Messrs. Oil India Limited on this day, 2000, after enumerating the standing trees, crops, etc. jointly. Some, my lord, similar orders at the, my lord, subsequent pages up to, my lord, page 67. So thereafter, my lord, we need to pay them the surface compensation. That, my lord, we have paid. That your lordship will find from, my lord, page 68. And the, my lord, the tea garden has a receipt. These are the receipts, my lord. Then, my lord, the 4 writ petitions which were filed, my lord, the judgment your lordship will get. My lord, the judgment starts at page 70, effectively, my lord, from page 75. Now here, my lord, I will not take your lordship to the, my lord, entire judgment. Page 79, your lordship may kindly come to, my lord, the final observations.
Yes.
Paragraph 8. Upon hearing the learned counsel for the parties and on a consideration of their pleaded stand, we are of the view that it would meet the ends of justice if these petitions are closed with the following directions. So the directions are at page 80. The Deputy Commissioner, Tinshukia, would take immediate steps, if not already taken, to initiate a process under the LA Act 1894 for compensation thereunder vis-a-vis the land of the petitioner company involved in the instant proceeding and in occupation of the respondent oil. In the meanwhile, the respondent oil has not yet if meanwhile the respondent oil has not yet submitted its proposal to the above effect, it would do so within 2 weeks herefrom with the Deputy Commissioner Tinsukia, whereafter the said authority would take steps in terms of clause 1 as above. My lord, the oil agreed to the land acquisition that your lordship will get subsequently at page 70, at page 78, my lord. Then 3, the Deputy Commissioner Tinsukia would act strictly under the provisions of the Assam Land Acquisition Act 1894. However, in utmost expedition in view of the time lag in between. The initiation would be done within 3 weeks herefrom, and it would be the responsibility of the said authority to obtain the fresh proposal from respondent oil, if in the meantime, though necessary, the same has not been submitted. The Deputy Commissioner Tinsukia would ensure that the process of acquisition of the land is speeded up, avoiding undue delay. The parties needless to say, would cooperate with this exercise to be so undertaken. Then 5, the acquisition proceeding should be completed within a period of 6 months. Now, my lord, these are the directions. Then, my lord, next page, my lord, paragraph 9. In course of the argument, the learned counsel for the petitioner has urged that the acquisition of the land, if done, the compensation awardable would relate to the period on and from which the same is initiated by a notification under section 4 of the Act, and thus its claim with regard thereto for the period prior to such proceeding would remain unattended. In the above view of the matter, we consider it appropriate to permit the petitioner company to lay its claim vis-a-vis the land of the for the period and for which the possession has been taken over by the respondent oil till the initiation of the land acquisition proceeding under the Act. If such claim is made by the petitioner company, the Deputy Commissioner Tinsukia would take a decision thereon after hearing both the parties and strictly in accordance with law applicable thereto. This issue would be independent of the one for compensation under the Land Acquisition Act 1894 and would be undertaken by the Deputy Commissioner Tinsukia parallelly and completed within a period of 3 months from the claim made by the petitioner. It is clarified that whatever amount meanwhile has been paid by the respondent oil in favor of the petitioner company would be set off against his claim admissible in law. The above-mentioned state authority has been entrusted with the responsibility which this court has considered it appropriate in the facts and circumstances of the case, more particularly to effect the resolution of the lingering dispute between the parties. It is expected that it would act in the right spirit and complete the process within the time frame fixed thereafter. So, my lord, this has to be, my lord, in 2 parts. That has been, my lord, directed. Then, my lord, the notification was issued under section 4 on 20th of May 2011. That your lordship finds at page 83 to 85. This is page 83 is a notification under section 4. Then section 6 notification, your lordship gets at page 86. And this is dated, my lord, 17/9/2011. Then, my lord, there was a meeting between the parties. And if your lordship kindly comes to page 89, your lordship will find, my lord, the agreements arrived at. May I read it, my lord? Page 89. Minutes of the meeting held in the office chamber of the DC, Tinsukia on 30th April 2011 relating to land acquisition matter of Okanpokuri Tea Estate by All India Limited for oil exploration. These are the members present. At the very outset, Deputy Commissioner welcomed all the members attended the meeting and informed that the meeting was convened in order to take necessary steps for settlement of the dispute between Messrs. Nandalal Sons and Tea Industries Private Limited and Oil India Limited, Duliajan, for acquisition of land which is already under possession of Oil India Limited, Duliajan, for the purpose related to oil exploration. In this regard, Honorable High Court, Guwahati passed an order in WPC number 1681/2002, communicated by letter number such and such, wherein it is directed to comply with the said order. With due permission from the Deputy Commissioner Tinsukia, Srimati K. Padmanabhan IAS Additional Deputy Commissioner read out the proceedings of the meeting held on 12th October 2010, Honorable High Court order, and also order by the Deputy Commissioner Dibrugarh for acquisition of the land by All India Limited in respect of the jurisdiction of Dibrugarh district for oil exploration, etc. Additional Deputy Commissioner Tinsukia informed that though the proposal for acquisition has been prepared by Circle Officer Tinsukia, the rate per bigha is still 5 lakhs as per Deputy Commissioner's order passed in 2005 for all oil-related acquisition in Tinsukia town and semi-urban areas within 3 kilometers. The rate has not been enhanced as government has returned the zonal valuation report of the district without approval and asked for correction to be made. Further, Dibrugarh district too has not yet finalized the value of the land in urban and semi-urban areas for oil-related acquisition. In view of the above, the rate of land as per 2011 rates could not be incorporated in the proposal as prepared. Deputy Commissioner Tinsukia informed the members that in the light of the facts stated by Additional Deputy Commissioner Tinsukia and in order to comply with the Honorable Court's order, an interim enhancement in rate specifically for Okanpokuri Tea Estate has also been made as per Circle Office Tinsukia's report. The rate of land sale deed is 2 lakhs 1,598 in 2005. The rate so fixed for oil related acquisition in town and semi-urban areas in 2005 was rupees 5 lakhs, which was approximately 2.48 times the rate as per the land sale deed. Similarly, the rate of the land as on date as per registered sale deed is 4,06,400, estimation enhancing this rate by 2.48 times. An amount of rupees 10 lakhs 7,782 is derived, which could be approved as the rate of land acquisition in Okanpokuri. Deputy Commissioner Tinsukia also asked the representative of the Oil India Limited, Duliajan and Messrs. Nandalal Sons Tea Industries Private Limited to opine their views and comments in order to make an amicable settlement of dispute in response to the Honorable High Court's order, subject to fulfillment of terms and conditions adopted by the Revenue Department, Government of Assam. Accordingly, both the representatives of aforesaid concern put up their suggestion and added that they would abide by the order passed by the Deputy Commissioner Tinsukia. So, Manat, this was the mutual settlement. In view of the above, the following decisions were taken in this meeting. The rate of rupees 10 lakhs and odd per bigha of land in semi-urban and Okanpokuri Tea Estate was approved to comply with the Honorable High Court's order. The rate was approved as a special case and will not be applicable to other oil-related cases. any enhancement of rate at a later date after the approval of zonal valuation would have retrospective effect on this case, provided Oil India has not yet done to full payment of the payment on this matter to Deputy Commissioner by this time. Now, my lord. The order that has been passed pursuant to my lord, this meeting, minutes of this meeting, that your lordship gets, my lord, at page 91. Whereas the land acquisition under LA Act 1884 has been initiated for acquisition of land, whereas approved so and so, my lord, this description, then my lord, your lordship may skip, my lord, these discussions. Last sentence, my lord, hence, I, Sri S.S. Meenakshi Sundaram IAS, Collector, Deputy Commissioner, Tinsukia, hereby fix the rate per bigha of land in Kukanpur 50 state, falling within so and so, so and so. And this is the, my lord, amount. The terms and conditions of the order is as follows. The rate of rupees 10 lakhs and odd per bigha for land in semi-urban areas, that is Hukanpukri Tea Estate, was approved to comply with the Honorable High Court's order. The rate was approved as a special case and will not be applicable to other oil-related cases. Then any enhancement, my lord? Then, my lord, if your lordship kindly see, this was, my lord, by the next page at page 93, my lord, this was communicated by the Deputy Commissioner to the Registrar of this Honorable Court. Page 93. In inviting a reference to the subject cited above, I have the honor to inform you that in the matter of acquisition of land for oil limited in the possession of Hukanpukri Tea Estate, Messrs. Nandalal Sons and Tea Industries Private Limited, the land acquisition proposal at current market rate has been prepared and forwarded to the government by this office letter number such and such, that is 7/5/2011. Against allegation number so and so for taking further necessary action. This is pertinent to mention here that though the zonal evaluation of the district in pending an interim rate per bigha has been fixed by the office by the order number such and such, dated 3/5/2011, based on the tripartite discussion held this matter, copy of the minus and order enclosed. Thereafter, my lord, what happened, that is also, my lord, not clear, my lord. It was sent to the registrar. But then, my lord, the Oil India Limited has written a letter on 11th May, page 94. Sorry, my lord, this is a letter by the Deputy Commissioner that I have on, my lord, typed on. Page 95. Oil India Limited wrote to the, my lord, DC, raising objection to the letter dated 18/5/2011 to, my lord, review the land value. Then application was filed for review, my lord. Page 95 it starts. Last but paragraph 9 at page 96, your lordship will find the reasons have been, my lord, given. In view of the above, we'd like to request your good self to review the valuation of the land as mentioned in your later minutes of the meeting order issued to do the needful accordingly. Then, my lord, government approved it, my lord, page 97. That estimate has been approved, my lord, that your lordship finds at page 97 to 100. In one case, and my lord, the other case, page 101. I am directed to forward here an approved copy of the land acquisition estimate of 39 lakhs. Then your lordship also find, my lord, the other one. Page 101, my lord, 5 crore 90 lakhs and odd. These have been approved. Now, your lordship may kindly come to page 106. This is a communication by the Deputy Commissioner to the my lord Oil India Limited. In inviting a reference to the subject, I am to request you kindly to deposit the estimated amount of rupees 39 lakhs and odd against LA case number 193 of 2011, and the next page, my lord, in respect of the other LA case. This was written, my lord, to the Oil India Limited. So, my lord, all these documents, my lord, why I am my lord, giving your lordship the trouble of reading all this, that, my lord, there was an agreement. On the basis of that, my lord, land valuation was, my lord, the calculated. It was approved by the government. And, my lord, although we had filed some, my lord, application for review of that, my lord, the amount, but, my lord, everything was finalized. Only our review part remains, but otherwise, my lord, the land acquisition proceeding has attained its finality. In spite of that, what happens, my lord? If your lordship kindly comes to page 108. The Deputy Commissioner, my lord, then again writes to the petitioner regarding payment of compensation. The amount, my lord, this has been discussed. Last sentence your lordship will read, my lord. Therefore, you are requested to deposit the aforesaid amount of compensation of the land under acquisition to the office of the undersigned immediately. One thing your lordship will kindly notice, my lord. This communication is dated 16 July 2011. But this was served on the, my lord, petitioner by a messenger on 5/11/2012. After about, my lord, 1.5 years. My lord, I'll show that. Page 109. The oil writes to the, my lord, Deputy Commissioner, reference above, please be informed that the letter on the reference, which was dated 16/7/2011, was received by us on 5/11/2012 through one of the messenger of your good office. It is therefore requested kindly to clarify the date on which the letter, the issue of the letter accordingly. So, my lord, the reason for such delay, that is also, my lord, not understood, and there is no explanation. Because, my lord, this amount was fixed, my lord, as a special case, and the delay of 1.5 years is also, my lord, not explained. Then, my lord, we had to come to this court. WBC 5372 was filed, my lord, and they also filed, my lord, 2 writ petitions, and this honorable court has directed that DC to revisit the provisions of the letter dated 67/2011. That your lordship finds, my lord, at page 111. No, judgment was, it starts at 111. This is, my lord, in respect of the writ petition number 5372 2013 by the Oil India Limited, and, my lord, WPC 587 and 5372 by the, my lord, the T State.
Page 110.
110, my lord.
How many writ petition?
There are 2 writ petitions, my lord.
Okay.
587. We have filed 5372.
Okay.
During tendency of the description, they have time.
5372 of 2013. And my lord, they had filed the writ petition 587 of 2017. And both these cases were, my lord, disposed of by this common judgment. The directions are at, my lord, page 112. Second paragraph. The petition is disposed of in the aforesaid circumstances as agreed by the parties. This writ petition is disposed of with a direction that the Deputy Commissioner cum Land Revenue Officer of Tinsukia District would immediately pursue with the land acquisition case number 192 and 193 of 2011 and bring the same to its logical end. Meaning thereby that the Deputy Commissioner will arrive at a definite determination as to what compensation is required to be paid to the petitioners.
Which page? Which page?
Page 112 I am reading, my lord. Second paragraph, in the aforesaid circumstances. In the aforesaid circumstances as agreed by the parties, this writ petition is disposed of with a direction that the Deputy Commissioner cum Land Revenue Officer Tinsukia District would immediately pursue with the land acquisition case 192 of 93 and 193 of 2011 and bring this to its logical end, meaning thereby that the Deputy Commissioner will arrive at the definite determination as to what compensation is required to be paid to the petitioners. Accordingly, it is directed that the Deputy Commissioner cum Land Revenue Officer Tinsukia District shall forthwith pursue with the land requisition case, it should be acquisition, 192 of 93 of 2011 and bring the proceeding to its conclusion and arrive at an appropriate determination of the compensation to be paid to the petitioners. The aforesaid exercise shall be completed within the period of 2 months from the date of receipt of the order. In terms of the above, writ petitions stand closed with regard to WPC 5372 of 2013, which had been filed by the OIL, which is the organization for whom the land has been acquired. It is seen that the writ petition is against the impugned letter dated 16/7/2011 of the DC Tinsukia District. From the said letter, it is seen that the Deputy Commissioner had fixed an amount of rupees 5 crore 90 lakhs and odd against LA case number 192 and 39 lakhs and odd against LA case number 193 of 2012. It should be 2011. Purportedly as per the order of the court in WPC 1680/2002, so and so 4 cases. It can be seen that the aforesaid writ petitioners pertain to taking over of the land of the petitioner by oil under Rule 89, 189 and 190 of the rules under the Assam Land Revenue Regulation. By the said writ petition, a challenge was made by the landowners to the aforesaid taking over of the land. By the order dated 5/4/2011, the said writ petitioners were closed without interfering the taking over of the land, but directing the Deputy Commissioner to take a decision after hearing both the parties and strictly in accordance with the applicable law. The aforesaid direction by this court in the judgment and order dated 5/4/2011 cannot be construed to be a direction by this court to the Deputy Commissioner that the Deputy Commissioner would make an assessment of the aforesaid amount without following any due procedure of law. In view of the above, the Deputy Commissioner is directed to revisit the provisions of the letter dated 16/7/2011
Where is
and
that
arrive.
page?
It starts at page 108. I am reading 113, my lord.
Okay.
Okay. So far as our petition is concerned, my lord, this is the direction. Last paragraph. In view of the above, Deputy Commissioner is directed to revisit the provisions of the letter dated 16/7/2011 and arrive at a proper and due compensation payable to the petitioners by following the due procedure of law. So my lord, all this suggests that, my lord, the acquisition process came to an end. Only, my lord, the determination of the compensation about there was a little, my lord, confusion, and that has been directed by this honorable court to be, my lord, settled.
That following the due procedure of law.
My lord. In the, my lord, repetition, we, my lord, we also, my lord, approached the deputy commissioner by filing a written statement, my lord, where we had taken our stand as to why, my lord, and how the amount is to be specified. Because, my lord, by this communication at page 114, my lord, we had again, my lord, asked the deputy commissioner that to revisit the provisions of the letter dated 16/7/2011, because that was the direction of this honorable court. But then, my lord, the order at page 116 was passed by the deputy commissioner. May I read it, my lord? 21st of May 2017, in pursuance of the order dated 8/2/2017 passed by the Honorable Guwahati High Court in WPC 587 and 5372, the, my lord, judgment that your lordship has just read, and for compliance, a meeting was caused upon inviting written statement from the parties, that is Oil India Limited at Hukanpukuri Tea Estate, in regard to the value of the land measuring 56 bighas 3 kathas, 3 lashas of village Hukanpukuri Tea Estate acquired for oil drilling purpose at Hukanpukuri Tea Estate, and whereas both the parties have submitted their respective written statement in support of their claim and objection in regard to the value of the land as determined in the instant LA case number 17 of 2008, and examining the case records of the land acquisition case of 17 of 2008, the Oil India Limited has not deposited the award amount till date, whatever be the amount, nor asked any time for depositing the award amount, consistent with the record that the Hukanpukuri Estate has not received any amount of award, and hence, as per the provisions of section 24(2), it is decided that since the Oil India Limited has not deposited the award amount as per section 11 of the LA Act 1894, hence the proceeding drawn under provisions of 1894, the same is deserved to be lapsed. In this context, the views furnished by the government pleader Tinsukia has also been seen. In view of the above, further proceedings in LA case number 192 and 193 of 2011 should be carried out as per provisions of the new Act. That is the Right to Fair Compensation and Transparency in Land Acquisition Act 2013, and to calculate the amount of compensation accordingly. Let the parties concerned be informed accordingly. In the meantime, Land Acquisition Branch of DC Office Tinsukia will prepare proposal for regarding quantum of compensation payable in accordance with the relevant provisions of the Right to Fair Compensation Act within a month from the date of passing of the order. So immediately, my lord, the oil, my lord, responded to this, that your lordship finds at page 117. Reference above would like to highlight the fact that the Honorable Guwahati High Court in its judgment dated 8/2/2017 in the subject case directed your good office to revisit the provision of the letter dated 16/7/2011 of your good office and arrive at a proper and due compensation payable to the petitioners by following the procedure of law. However, contrary to the same, in your order dated 21/5/2017, in the case, your good office passed an order for processing the case under the new Right to Fair Compensation Act 2013 and calculate the amount of compensation accordingly under the new Act of 2013. So, my lord, contrary to the direction that has been passed by this honorable court, my lord, this has been held and we have, my lord, responded and objected to it. In view of the above, we'd like to request your good office to look into the matter and review or apposite order dated 21/5/2017 as per the directive.
Order
of the-
is page 116 has been challenged.
I am reading my lord 117, my lord.
116, page 116 order has been challenged.
No, after this, my lord,
Yes. Submitted an objection. I could
this
understand.
is the objection before the, my lord, the deputy commissioner, because my lord court directed that you hear both the parties and pass an order determining the compensation. Instead of that, my lord, the deputy commissioner, my lord, says that since you have not paid the awarded amount, therefore the land acquisition proceeding will start under the new act.
No, in the judgment, two parts.
My lord.
As per you, 110, common judgment.
My lord.
Deputy Commissioner pursued the land acquisition case, bring the proceeding to a conclusion,
Yes, my lord.
and arrived at an appropriate determination of compensation to be paid to the petitioner. And another one is revisit the letter dated 16/7/2011 and arrived at a proper compensation amount.
My
These are the two.
Yes, my lord. These are the three directives.
Then super, you have submitted your
Written statement.
representation.
Yes, my lord.
He 116. He said submitted the respective written statement
My lord.
in support of their claim and examining the case record. So explicitly it is 16/7/2011 was not there.
My lord, if your lordship comes to the order that has been passed in the two repetitions together, my lord, as my lord pointed out, there are two parts. So far as the repetition of the petitioner, my lord, oil is concerned, that direction your lordship finds at the last paragraph of
Yes.
113.
This is a step towards that.
Yes.
This order is a step towards that.
Revisiting that particular order, my lord, earlier order of compensation.
This is a step. It cannot be a one stage. Land acquisition proceeding is not a one step thing.
No, my lord, what I am trying to, my lord, impress upon your lordship is that, my lord, the parties met with the deputy commissioner and my lord, and compensation amount was fixed, my lord.
That is got diluted in the process.
Because, my lord,
Because
my
you
humble
have taken into so many things, but in the process, I thought that it is
on the ground that, my lord, that amount which has been, my lord, fixed in the, my lord, meeting by
meeting that was in which year?
Resolving the matter, my lord.
Which year? That was in which year? That was in 2011.
2011, yes, my lord.
Right. That is the order, page 91.
Yes, my lord.
Right. This is also with a rider. Any enhancement of rate. Rider is there. Would have retrospective effect.
The retrospective effect is, my lord, in respect of, my lord, any subsequent enhancement.
Then all this approved land acquisition estimate. Okay. Then he asked you to deposit the amount. Calculated on the basis of 10 lakh, that amount.
Yes, my lord.
7 lakh per biha.
Yes.
Right? Then you objected to it, perhaps.
My lord, we requested for, my lord, revisiting that, my lord. We wanted a review. Then, my lord, this honorable court also directed, my lord, he should revisit that order. That has not been complied with. Instead, my lord says that since you have not paid the awarded amount, so it will proceed under the new act.
That is one part of objection. Any other?
Then, my lord, your lordship may. There have been many communications in between, my lord.
And this 116 order has been challenged.
Yes, my lord.
Where?
That your lordship will find. No, before that, the award that has been, my lord, the awarding 10 crores and odd, my lord, that your lordship finds at page 120. Then petitioner's objection,
Submission of award
131, my lord.
to the commissioner. Page 120.
131 is the, my lord, order.
120.
No, my lord, the one. My lord, the order that has been passed, my lord, in writ petition 7797, that your lordship finds at page 131. 131.
Because 113. Last part.
Yes,
The deputy
113 is
commissioner
the-
is directed to revisit
Yes, my lord.
the provisions of the letter dated 16/7/2011. This is one part.
Yes.
And arrived at a proper and due compensation
Yes.
payable to the petitioner by following the due procedure of law. By that 10 lakh is gone. That earlier 10 lakh, perhaps, is gone.
My lord, my submission is that, my lord, that was a mutual.
If due
settlement.
procedure,
Yes.
it means due procedure in the statutory provisions.
No, what I am on is that, my lord, the matter was amicably settled by the
Yes.
parties and an amount was fixed. We
Right.
said that please revisit it and we do not pay. And therefore, my lord, the deputy commissioner says that it will proceed against the matter 2013. What I submit is that, my lord, it has already, my lord, culminated into a final order.
Which one?
That, my lord, the paying of 10 lakhs and all.
10 lakh.
Yes. 10 crores. Crores, no?
10 lakh per bigha.
Per bigha, man.
10 lakh per bigha.
Per bigha, man.
Which was arrived in by the order dated 3rd of May 2011.
Yes, my lord.
Water has been flowing through Brahmaputra. Water is flowing through Brahmaputra since
Maybe, my lord,
2011.
we could be made liable for interest.
Let us see. Let us see that order challenged. But
This is an interim order, my lord, page
that
132, which starts.
21st May 2017 order has been challenged.
Your lordship may kindly come to page 131, my lord. This is the order, this is the repetition.
Page 130.
131, my lord, Oil India Limited. Small order. 15/12/2017. The petitioner is a government undertaking and is involved with the oil exploration in the Upper Assam region covering Tinsukia and Dibrugarh districts. The concerned land of Mrs. Nandalal and Sons Industry Private Limited were identified, and accordingly the oil had limited took possession of the land in the year 2000. The collector fixed the payable compensation, but the same came to be challenged by the landowner. Those analogous cases were disposed of by the division bench on 5/4/2011 with direction to the DC to afford hearing and determine the compensation under the Land Acquisition Act 1894. The amount already received by the landowner towards surface damage compensation were to be excluded from the exercise to be undertaken by the DC. Pursuant to the aforesaid direction, the LA case number 192/11 and 192/11 were registered and notices under section 4 and 6 of the LA Act were issued. The DC Tinsukia deliberated over the matter and on 3/5/2011 determined the rate for the semi-urban land of the Pukanpukuri Tea Estate. It was, however, clarified that the high rate was approved as a special case and will not be applicable to other oil-related cases. The decision of the Tinsukia collector was immediately challenged by the oil company and also by the landowner. Both WPC number 587 and 5372 of 2013 were analogously, my lord, that flowing of water for so many years, we came to this court in 2013, my lord. 2013. They came, my lord.
Got it stayed.
My lord.
Got it stayed.
Yes. Now, my lord, by this order, were analogously disposed of on HMN by the High Court. The learned judge noted that the Deputy Commissioner should make the determination as per the LA Act, and accordingly he was directed to revisit the order and determine the appropriate compensation. Following the above direction of the court, the BC has, however, acted under the Right to Fair Compensation Act of 2013 and fixed the payable compensation for LA case number so-and-so at rupees 10 lakhs and 71 lakhs respectively, SNE 10 crores, 10 crores 81 lakhs and 71 lakhs. Assailing the legality of the above process, Mr. Asan Sharma, the learned senior counsel, submits that the assessment of the compensation under 2013 Act for the already acquired land is wholly irrational. The senior counsel submits that the lapsing of the earlier proceeding under 1894 Act by application of section 24(2) of the Act 2013 is currently being examined by the Supreme Court in SLP number such and such, Yogesh Nima. In view of the above, let notice returnable in 4 weeks be issued. So and so in the interim operation of the two impugned orders dated 15/9/2017 of the deceased Tinsukia estate.
This is at your instance.
Yes, ma'am. At my instance. And then, my lord, we will have to, my lord, examine the provisions of section 24(2), my lord. That will come a little later, my lord. Thereafter, this is the order, my lord, final order. No, this is not a final order, my lord. The court directed that let the matter be listed after the SLP is disposed of, because, my lord, it was submitted that an assembly is pending with respect to the, my lord, interpretation of section 24(2). This is order dated, my lord, 19/4/2018. Now, if your lordship kindly comes to paragraph 4, considering the submission of Mr. Bonik at specific queries put to Mr. Sharma, learned Senior Counsel of Oil India Limited, whether there is any solution to bail out the respondent number 3 from the financial hardship faced by them, Mr. Sharma submits that respondent 3 has blocked the entry of the personnel of the petitioner company, which has caused immediate. Now, finally, my lord, it was directed that let the matter be decided listed after the SLP is disposed of. So, my lord, the stay continued. The last paragraph, my lord, of page 136 may be relevant, my lord. Considering the situation, this court is of the opinion that let the petitioner company pay an amount of rupees 1.5 crore to be deposited in the provident fund amount of Assam Tea Employees Provident Fund within a period of 1 month from today, and immediately thereafter the respondent number 3 will permit the personnel of the petitioner company to enter into the garden. We have paid that amount, causing any further blockage. Accordingly, order which was passed on 15/12/2017 is modified to this extent. The amount so deposited by Oil India Limited is a subject to adjustment against the total award to be fixed after the issue, which is subject matter of this writ petition, is adjudicated. Then page 29 is the, my lord, proof that, my lord, we have paid that, deposited that 1.5 crore. Page 138, 139. Then, my lord, the finality in this writ petition was arrived at is 140, my lord. This writ petition was finally disposed of. May I read that, my lord, the operative part of that order? Paragraph 3 may be important, my lord. Paragraph 3 of the judgment. At page 143. A reading of the aforesaid extract of paragraph 9, that is the, my lord, extract of the earlier order dated 5/4/2011 in WPC 1680/2002 and other writ petition makes it discernible that the division bench has distinguished the period of taking over the land by All India Limited in two parts. The first part being the stage prior to issuing the notification under Section 4 of the LA Act, and the other part being the period subsequent to issuing of notification under Section 4 of the Act, 1894. In the premises, the division bench provided that the claim of the landowner for compensation for the period prior to notification under Section 4 of the Act of 1894 being issued, the Deputy Commissioner would take a decision after hearing both the parties and strictly in accordance with the law applicable thereto. But the issue would be independent of the one for compensation under the Act of 1894. In other words, the division bench has made it explicitly clear that for the period prior to issuing the notification under Section 4 of the Act of 1894, the Deputy Commissioner would take a decision on the amount of compensation that the landowner may be entitled to, and such decision shall be independent of the compensation that is required to be paid under the Act of 1894. In the process, the landowner, Nandalal and Sons Steel Industries Private Limited, instituted a subsequent writ petition being WPC number so-and-so, raising the issue of delayed payment by the writ petitioner, All India Limited. And whereas WPC 5372 of 2013 was instituted by Oil India Limited, raising the issue as regards the order dated 16/7/2011 of the Deputy Commissioner Tinsukia, the order dated 16/7/2011 of the DC is extracted below. That your lordship has, my lord, already seen. Then, my lord, next page your lordship may come, paragraph 5. By the order dated 16/7/2011 of the Deputy Commissioner Tinsukia, the appropriate authority of the All India Limited was informed that the Deputy Commissioner had fixed an amount of rupees 5 crore 90 lakhs and odd in respect of LA case number 192 and 39 lakhs and odd in respect of LA case number 193 of 2012. The communication also provided that the said fixation by the Deputy Commissioner was as per the order of the High Court dated 5/4/2011 in WPC 1680 of 2002 and other writ petitions which had already been referred herein above. The Deputy Commissioner in the communication also provided that the valuation was made by taking the value of the land to be 10,07,872 per bigha. The aforesaid two writ petitions had been given its consideration in the order dated 8/2/2017, by which a tentative conclusion was arrived at that no award could be located to have been made by the Deputy Commissioner under Section 11 of the Act of 1894. There lies the problem, my lord. Accordingly, the Deputy Commissioner was directed to revisit the order dated 16/7/2011 and arrive at an appropriate compensation that may be payable to the landowners. As regards the other part of the judgment dated 5/4/2011 in WPC 1680 of 2002 and other writ petitions, it was provided in the said order of 8/2/2017 that the Deputy Commissioner may take his own decision as regards the compensation for the period prior to the notification under Section 4 of the Act 1894 being issued. In the aforesaid circumstances, the present writ petition is instituted assailing the order dated 21/5/2017 of the Deputy Commissioner. The order is extracted below. In pursuance of the order dated 8/2/2017 passed by the Honorable Guwahati High Court in WPC 587 and 5372, and for compliance of a meeting was caused upon by the inviting written statement from parties that your lordship has already read, my lord. In view of the second paragraph, in view of the above further proceeding, in LA case number 192 and 132 2011 should be carried out as per provisions of the new act. That was the my lord finding. Then my lord, next page, paragraph 7. A reading of the order dated 21/5/2017 makes it discernible that the Deputy Commissioner had arrived at this conclusion that the amount of compensation awarded against the petitioner All India Limited had not been deposited by them. Therefore, in exercise of power under Section 24(2) of the Right to Fair Compensation Act 2013, the earlier award under Section 11 of the Act has been lapsed. Mr. So-and-so, learned senior counsel for the petitioner, All India Limited, had erased the contention that Section 24(2) of the Act of 2013 begins with a non-obstante clause and is subject to the condition precedent that the award made under the Act of 1894 ought to be of 5 years or prior to the date on which the Act of 2013 had come in force. In the instant case, the learned senior counsel points out that as per records, no such award is available which may have been made prior to 5 years of the date on which the Act of 2013 had come into force. We have perused the records produced by so-and-so, learned government advocate, appearing on behalf of the Deputy Commissioner Tinsukia. Except for an order bearing number such and such dated 3/5/2011 of the Collector cum Deputy Commissioner Tinsukia, no further order is noticed which may be in the nature of an award made under Section 11 of the Act of 1894. In the said order, it is provided as extracted. Whereas land acquisition under LA Act 1894 has been initiated for acquiring land for Oil India Limited in Hukanpokuri Tea Estate, currently under possession of the Oil India Limited as per Honorable High Court's order in WPC 1631 of 22. Whereas approved land value as per DC Tinsukia's order dated 19 July 2005 stands at rupees 5 lakh per bigha for land in Tinsukia town and semi-urban areas with 3 km. Whereas as per the decision taken during tripartite meeting held on 12/10/2010, as per the Honorable High Court's order between the District Administration, Oil India Limited and Hukanpokuri Tea Estate, land acquisition proposal is to be submitted at current market rates. Whereas the process of zonal valuation of Tinsukia district is still underway. Whereas without government approval of zonal valuation, Tinsukia district land valuation oil related to acquisition as on 2011 cannot be fixed by the Deputy Commissioner. Whereas as per Honorable High Court's order dated 18/2011 in the same case, duration of 4 weeks was given for submission of the land acquisition proposal for the said land of Hukanpokuri Estate to collector. Whereas as per tripartite meeting held on 30/4/2011 in the DC office Tinsukia, both parties agreed to abide by the order of the DC Tinsukia for enhancement of land value in Hukanpokuri Estate as an interim measure, pending approval of zonal valuation report. I, Sri Meenakshi Sundaram, this is the order, the rate of 10 lakhs per bigha. A reading of the order dated, paragraph 11. A reading of the order dated 3/5/2011 of the Deputy Commissioner Tinsukia does not enable the court to arrive at a conclusion as to whether the said order fixing the rate of rupees 10,07,872 per bigha is an award under the Act of 1894. A perusal of the records does not make it discernible that there exists any award under Section 11 of the Act of 1894, which was made prior to 5 years of the date of the Act 2013 coming into force, although a confusion may remain whether there is any such award in existence, but at least no award is discernible which may have been made prior to 5 years of the date of the Act of 2013 coming into force, which came into force on 1/1/2014. As no award is available on record that may have been made prior to 5 years of the date of the Act of 2013 coming into force, we are in agreement with the submission of the learned senior counsel, Mr. Equinar, that the provisions of Section 24(2) of the Act of 2013 would be inapplicable in the present case. As the provisions of Section 24(2) of the Act of 2013 would be inapplicable, the conclusion arrived at by the Deputy Commissioner Tinsukia in his order dated 21/5/2017 would be unsustainable in law, whereby a conclusion is arrived at that in view of the provision of Section 24(2) of the Act of 2013, the earlier proceeding under Section 11 of the Act of 1894 had lapsed in the meantime. But a further issue would remain whether there is any award made by the Deputy Commissioner at all in the opposite proceeding. If the Deputy Commissioner, upon perusal of his own records, can find out whether there exists an award which may have been made under Section 11 of the Act of 1894, the provisions of Section 24(1)(b) of the Act of 2013 would be applicable, and in such case, whatever award is available on record, the same has to be brought to its logical end, meaning thereby that the beneficiaries of the land would have to make the payment of the compensation to the landowner. If, on the other hand, no award can be found out by the Deputy Commissioner Tinsukia from the records which may have been made under Section 11 of the Act of 1894, the provision of Section 24(1)(a) would be made applicable, meaning thereby that the provisions of the Act of 2013 would be applicable in respect of the compensation that is to be made to the landowner, namely Nandalal and Sons. Accordingly, paragraph 14 at page 151. Accordingly, we direct the Deputy Commissioner Tinsukia to look into the records and arrive at its own fair conclusion. In the event an award under Section 11 of the Act of 1894 exists, the implication thereof be followed so that the landowner receives the appropriate compensation for the land that had been acquired. And if, on the other hand, the Deputy Commissioner Tinsukia arrives at his conclusion that no award has been made under Section 11 of the Act 1894, the provision of Section 24(1)(a) be made applicable and the process be brought to its logical end. The entire exercise to be completed by the Deputy Commissioner within a period of 3 months from the date of receipt of the certified copy. But nevertheless, to arrive at the conclusion whether there exists any award or not, a reasoned order be passed within a period of 1 month of the receipt of the certified copy of this order, and thereupon bring the process to its logical end within a period of another 2 months. As regards the compensation to the landowner for the period prior to issuance of Section 4 notification, the Deputy Commissioner is directed to expedite the process and make a determination and pass a separate reasoned order within the period of 3 months as indicated above from the date of receipt of the certified copy. We have taken note that the connected requisitions being WBC 6290 of 17 filed by the landowner respondent number 3 herein, namely Nandalal and Sons, is for payment of the appropriate compensation, and the provision of this order shall also be made applicable in respect of WBC 6290.
So we have to close it today at this point.
My lord, at least, my lord, the facts I have placed, then my lord, I'll submit.
Question is, it is 24(1)(a) or 24(1)(b)?
Or 24.
That is one of the points.
Yes, my lord. In fact, that is the main-
24(2) is out of question.
Yes, my lord.
So 24(1)(a) or 24(1)(b)?
B. And my lord, on that, my lord, there are decisions of the Honorable Supreme Court. I'll place that and your worship will eventually, my lord, decide which is applicable. The facts, my lord, I have placed more or less completely. I am grateful to your worship, my lord, for giving the patient hearing. Because, my lord, there are so much of facts.
Yes.
Too many cases, so many litigations. And ultimately, my lord, it is the public exchequer which will be affected.
Itu পাঠার কি বলবো? কিন্তু একটু পাঠার তো পুরোনো তো। এই না, দিয়ে একটু জন্মালি। ও, it is great. We can put it on 8/5.
8th of May, my lord. 8th of February.
Mr. M.K. Chaudhary, learned Senior Counsel, stated by Mr. K. Kolita, Learned Counsel Court of Appeals. Has advanced his submission. As his submission is not complete, let the case be listed again on 8/5. Ms. G. Goswami, Learned Counsel for respond number 5. Mr. Dinath, Learned. Deputy Commissioner. Okay. Revenue. R. Borbujari. Revenue 1, 2, 3. D. Nath, Senior Government Advocate. 4. MSG Goswami, Learned Counsel for the husband of 5 are present.
15th.
8-5.
My lord, on 8-5, I have got a very long matter fixed, my lord. So any other date, my lord, can it be on? Will 15 be too long, my lord? Will 15th be too long, my lord?
15. 13.
13 also could have asked, yes, 13.
13.
Yes, number.
13.
Lordship, 13 may be a difficulty. Sorry, Your Lordship.
I'll tend to forget then. Mr. Gochoru has again have to make submission for 1 hour like
We'll provide a list of dates, my lord.
also. And you provide bullet points also.
My lord.
Madam,
13,
15.
13, 1, 3,
that's difficult.
Let me 15, my lord.
15.
15th, my lord.
Obliged.
I'm highly obliged.
Obliged.
Full advance, not further hearing. Yes.
15, no?
Yes. Anything?
Obliged.
There are
Item 5.
item 5.
5. Interim is there and a date may be fixed for sure.
5.
Cooperative society election, 3 years already gone.
Huh?
3 years already gone.
They are enjoying otherwise interim order.
This is the case due to positive time. Mr. M.K. Hussain, when do you want?
20th of May.
What is the matter about? I have posted it.
No, madam. That's it. It was,
I am not, I don't remember. No. Please the case 25 2005.
and there is one matter, my lord. Item number 19, my lord. There I am appearing for the petitioner. That may also come on the same date, sir. Item number 19, last item.
Okay, under prayer, Mr. S. Doctor, Learned Counsel for the petitioner, Senior Counsel for the petitioner. This is the case on 20.
Item 5, interim.
Interim order passed side. To continue. Item number 5. What?
Item number 9 is an interim order. Item number 9 is an interim order.
9. Yes, I do. On the prayer of Mr. R.S. Mishra, please the case on side.
Diplo.